Good morning.
Good morning, Judge.
Morning. All right. I hope everyone is staying warm.
Trying.
Right now, we're taking up the receivership motion for contempt and sanctions on DF 2308365.
Yes, ma'am.
Okay. And I wanted you all to know I'm going to record this because you all have so many exhibits. And because we're doing it live, I don't have my what do you call it? The real time in front of me. So I'm going to record it so I can go back just in case I miss anything.
Yes, Your
Right?
Honor.
Okay, Judge. It just
So
told
it's
us we're being recorded, so I think you're on.
great.
And
So
Your
the
Honor,
exhibits, oh, go ahead.
my working from home, my computer camera decided not to work today.
Okay.
I don't know if it seems to be an issue on my laptop. I do apologize. I don't seem to be able to get it working. If
Okay.
you would allow me to leave and come back in, I might be able to reset my Zoom settings doing that, Your Honor.
Sure, that's fine.
Okay, thank you so much.
You're welcome. So we're going to give him an opportunity to come back. And then the next case that we will be taking up is, let me get you the case number, DF 2418397, C Strong.
Good morning, Judge Marla Pittman here on behalf of petitioner movement Casey C. Strong.
And then Denisha C. Strong, are you represented by counsel?
No, ma'am.
I see two screens for you.
Oh, my phone was on one as well because I had connection issues, so I can go off my phone.
Okay. Okay. Because I hear some feedback, just it's a little.
Let me get out of one. Is that better?
Your
Oh,
Honor,
it's still messing up.
yes, Your Honor, I do apologize.
No, you're okay. We're snowed in, so everybody has some sort of network issue. I know our lights went out briefly last night, so I get it.
Judge, for
Joey,
what it's worth, we think that sounds like Mr. Loftus.
Joey has to give me some direction on it because she's the one that has to write down everything. So, Joey, he doesn't have video.
That's what, Mr. Loftus, are you going to be questioning the witness or
Yes, I'll be questioning.
I think you should, the sound is very clear, so we should be good. If I need you to slow down or anything, I'll let you know.
Perfect. Thank you so much.
Let's do the exhibits first. Let's go ahead. They were pre-admitted, and I have a lot of them. So bear with me. I have the second amended petition for divorce, respondent's original answer, and that is Mrs. Layden's answer. Then I also have an original answer from Mr. Layden. I also have the brief in opposition. I'm not sure if that's an exhibit, but that's what I have.
Yes, Your Honor.
All right. So let's start with the receiver's exhibits first that were pre-admitted.
Yes, Your Honor. I've got three exhibits. Receiver's Exhibit 1 was a court order entered on June 26, 2025 from a May 27th, 2025 hearing. Receiver Exhibit 2 is a June 26th, 2025 hearing from a hearing on June 25th, 2025. And Receiver Exhibit 3 was a snapshot in time attorney's fees from July 2nd through January 20th, 2026.
Okay.
I have incurred additional fees, but I don't have a updated record to reflect that.
Okay. All right. And Attorney Northam,
Yes, ma'am.
your exhibits.
Judge, I think all you have from us is the informal settlement agreement.
Okay. I saw that.
And then,
that's
Judge, you
exhibit
all,
one.
yes, ma'am. And then you also said you had our answer, but we filed the first amended answer, I believe, on Friday. I just wanted to make sure you saw that that's in your queue.
It hasn't been accepted yet. I believe Brittany said to me this morning.
Okay. Okay. I just wanted to make sure you had that in front of you, Judge. Thank you.
You're welcome. Were you using that as an exhibit, or you just wanted me to take judicial notice of all the pleadings?
Yes, ma'am. It just asserts our defenses, so I wanted to make sure that was before you.
Okay, thank you.
Thank
and
you,
Attorney McDowell.
Yes, Your Honor. We should have our financial information statement. Let me see. I have these. We have, let's see. Respondents Exhibit 1 is copies of checks or payments that were made to Mr. McCullough, the movant, sorry. And then Respondents Exhibit 2, Your Honor, is correspondence between Mr. Loftus and myself and my office regarding resolution in support or to be used for attorney's fees. And then Respondents Exhibit 3 is a monthly financial information sheet of my client, Mr. Layden. And then we filed a brief in opposition outlining our objections to the motion and the legal grounds in addition to the answer that we filed that we're asking the court to take judicial notice of.
Yes. So the court admits petitioners exhibits 1, 2, and 3. Respondent.
Do you want to go on the record first? Do you want to go on the record?
Oh,
or we not
yes, Joey.
Okay, let's
Thank
go.
you.
You're welcome.
All right. We're on the record in cause number DF2308365. Counsels, will you please announce for the record?
Reed Loftus for the movement receiver Kelly McCullough.
Ashley McDowell on behalf of respondent Brian Layden.
Good morning, Judge Josh Northam on behalf of the respondent Rachel Layden, and I also have my associate Emily East on with me this morning.
Okay. Thank you all. Would those who intend to testify, please raise your right hand. Okay.
Rachel.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Oh, Miss Layden, you're on mute. Here, I give you a prompt.
Okay, I got it. Yes, ma'am.
Thank you. All right, we are set here today on the petitioner's motion for the receiver's motion for contempt as well as sanctions. Prior to going on the record, there was a stipulation to some pre-admitted exhibits, and they will now be admitted at this time. So, wait a minute, did someone drop off? Okay, I thought I heard the noise for someone to drop off. Okay, so petitioners exhibits 1, 2, and 3 are admitted. Respondents exhibit 1 is admitted. Respondent Ashley Layden's exhibit 1 is admitted. Respondent Brian Layden's exhibits 1, 2, and 3 are admitted. And the court takes judicial notice of all contents of the court's file.
And Judge, just to clarify, that's Rachel Layden on my exhibit.
Rachel, I'm sorry, it's Ashley McDowell.
It's okay. It's all right.
Rachel.
That's all right. I just know your microphone.
I'm sorry, Mrs. Layden, I changed your name.
No worries. No worries.
Okay. So I set you at 20 minutes aside. That will include any open and closing statements should you all choose to make one. I briefly looked at the Mr. Layden's brief in opposition, but I will have an opportunity to take a better look at that once I'm at the courthouse and I have full access to my Odyssey screen. And so I'm going to, you all are just give testimony. As I stated prior to going on the record too, we're going to record this because we are streaming live, and just in case I miss anything, I can go back and look at it. So at this time, let me see. Attorney Reed, would you like to make an opening statement?
Yes, Your Honor. And I may have filed a motion for contempt. I don't practice typically in family court, so motions to enforce are not something that is a typical part of my practice. In reality, what I'm trying to do is enforce 2 court orders entered by this court to pay the receiver that's been ordered by the court for services that were provided as he was appointed by this court. And the outstanding balance is currently about $38,000 to be paid by him. And the court issued 2 separate orders, one for $9,100, one for $29,622. And I'm just seeking to enforce those orders and have had to incur, my client has had to incur legal expenses in trying to enforce those orders. Your Honor, I never intended or thought that the court would throw either Mr. or Miss Layden in jail for this. And I'm just in trying to get my client paid, which he's rightfully due and owed this money as ordered by the court.
Okay. Thank you, Attorney Reed. Attorney McDowell, would you like to make an opening statement?
Yes, Your Honor. There are two orders, as Mr. Loftus said, before the court today. One, which I'll call order number one, is ordering Mr. Layden to pay approximately $9,100 to Mr. McCullough for services rendered in conjunction with being appointed as a receiver. Order number two is ordering petitioner, and I'll use that in terms of the divorce. In the divorce action, petitioner is Rachel Layden, and the respondent is my client, Mr. Brian Layden. And in that second order, order number two, it is ordering petitioner and or respondent to pay the approximately $29,000 to Mr. McCullough, who retained a third party, Janik Forensic, to do forensic accounting work in conjunction with the receivership. Our position, Your Honor, as outlined in our brief, is one, it's not enforceable by contempt because it's a failure to pay a debt. Two, this order number, we say that the order is not specific enough to be held for a party to be held in contempt. And number three, Mr. Layden, and I cannot speak for Mrs. Layden, but Mr. Layden was never personally served with this petition that states it's seeking contempt. The petition for the motion for contempt in and of itself is not specific as to the relief that it's seeking other than stating contempt and sanctions. So we have filed our brief in opposition to that. We think that the evidence that you'll hear today will show that these parties, that Mrs. Layden requested a receiver in this action, Mr. Layden agreed to the appointment of a receiver, and Mr. McCullough was hired as a receiver or appointed as the receiver in this case. The fees that were incurred in conjunction with that are now a community debt, but the only two orders before the court today are these two orders. And I think the court will hear that subsequent to these orders being entered, Mr. and Mrs. Layden reached an informal settlement agreement as to the resolution of their divorce. And at the time that backing up for a second, at the time that these two orders were entered, Your Honor, there were no minor children. They have not had any minor children for over a year and a half. I believe that's correct, at least a year and a half. And I think that's relevant because Mr. Northam's amended answer has now pled that this is for some of these fees were incurred for the conservator, related to the conservatorship of it. And Your Honor, we're asking the court to deny Mr. Loftus's motion.
Thank you, counsel. Attorney Northam.
Good morning, Judge. Judge, while I am in favor of Mr. McCullough and his firm being paid the fees that they are due for work that they did, that was quality work, I have to join Ms. McDowell in her complaints about the form of the motion and how it's presented here to the court. I believe you are going to hear and see that there are procedural defects of this motion that should require Mr. Loftus to replead, given the nature of the relief that he is requesting. We do believe that there is an intervening settlement agreement that's been filed with the court that puts the obligation to pay these fees on Mr. Layden. We believe if you get to testimony, and I'm not sure that you can, that the testimony will show you Mr. Layden and his business dealings were the cause of the receiver to begin with, and he subsequently made an agreement to satisfy those fees. I do, however, agree with Ms. McDowell that is a separate cause of action, not by this motion, and that this particular motion is defective.
Okay, thank you. If I'm hearing you all correctly, well, specifically you, Mr. Northam, you used the word replead. Why didn't anyone file a special exception?
Well, actually, because it's a contempt motion, Judge, and procedurally, I'm not required to do that. I don't believe under the case law. So that's the only reason, just to preserve due process.
Yes, Your Honor. I agree with Mr. Northam.
Okay. I was just curious because you used the word. So I was like, okay, we can do a special exception. But I get it. I understand.
Yes, ma'am.
Okay.
Your Honor, in regards to due process requires the defending party knowledge and ability to defend themselves. Both Ms. Layden and Mr. Layden have both shown up to this hearing today, both have counsel, and both have presented defenses. So any due process arguments, I believe, have been waived by their active defense in this case.
Yeah, we
Not
disagree, Judge.
exactly.
Yeah.
No, not exactly. So what the court is going to do is yeah, because what was I about to say? Due process rights can never be waived because they're embedded in subject matter jurisdiction. So
Judge, if Mr. Loftus wants to call his first witness, I'm happy to proceed with my motions after he's called his first witness.
okay. All right.
But Your Honor, if it's time and everybody's resources, I'd rather just go refile and we can reset the hearing as a motion to enforce, and we can save expenses today for my client who's continuing to have to pay me just to try to get paid on these court orders.
Okay. Is everyone in agreement with that?
Yeah, Your Honor, I think that's fine. I don't think that he will be able to replead in such a way because of the drafting and the wording of the original orders. But I believe the original orders are too vague to be enforced, I guess is what I'm saying, Your Honor. And I don't think, I think that
So
even if.
Yes, Your Honor, if we take that up today, that would be fine. Apparently there's no way to clarify, so there's no way for my client to get paid, Your Honor.
I'm sorry, Reed, I didn't mean to talk over you.
Yeah.
I believe, Your Honor, the only way
I was about to say Joey was going to stop you all in just a second. Go ahead, Attorney Reed.
Your Honor, if we don't think a motion to clarify, then there's no way my client could ever get paid. And I don't know how a order that says shall pay to receiver the sum of $9,100 by June 26th is vague or needs clarity. But if Ms. McDowell believes that it does, I guess I'm just at a loss for what to do to get my client paid here, Your Honor.
Okay. Attorney McDowell?
Your Honor, I think that the court will hear today or later is that my client has made payments of $750 for the past 4 months to try to work towards a payment of that. I'm happy to put on evidence of that. I think that this is a drafting problem. I don't think the court has the ability to add terms or language to that. And I think that Mr. Layden is trying to comply with their order. It's just not in the manner in which they want him to comply.
Yeah, and that would be an issue because I cannot make substantive changes to the order. I can only further clarify terms that are already there. And if the underlying order is defective, yes, not much the court can do. Then definitely enforceability will be an issue. And in Attorney Reed, that will be the issue, even if I were to reset, this issue would come up later. Because
Your Honor, I don't think the orders are overly vague. It says either respondent and or petitioner shall pay the receiver. To me, that's joint and several liability upon both or the community estate. I don't know what the procedural defect or defect in the orders are. And this is the first they've truly been raised that these orders are defective. So I don't know how that
it sounds like there would be an issue on enforceability because the court orders they're not supposed to, the court's intentions were. It has to be very specific. Otherwise, it wouldn't survive any challenge on a technicality as such. So I believe that'd be the issue because if you're to proceed, Attorney Reed, I already know what Attorney Northam is going to do. And that would essentially destroy the motion altogether.
I'm not sure I understand what Mr. Northam would do that would destroy the motion altogether, but so Your Honor, I guess if you're saying my client, there's no way to get my client paid in this, and he just needs to write off this debt that he incurred as being a court-appointed receiver, then I feel like I need to be able to advise my client. Because that seems
I'm not
to be
saying there's no way to get paid. I just when these sorts of situations happen, what the court and all parties to do is try to work out an agreement to see what you can, because if there's a meeting of the minds between the other two attorneys that, hey, this is a drafting issue, and it's no fault of your own, Attorney Reed, if there's a drafting issue and the court is in a position where it cannot modify or change that order, coming to an agreement would be best, especially if both sides are willing to comply. because they understand what the order was trying to get them to do, but enforceability wise, it just can't be done that way. That's what the court encourages, because when this happens, it really does put someone like your client in a bind, because there's no way to enforce what you're trying to do, if that makes sense.
I understand the court's position, Your Honor.
I guess, Attorney Reed, how would you like to proceed? Would you and counsels like to convene and have a meeting, or, because like I said, if you were to proceed, I know what Attorney Northam, and I know you're not familiar with family law, but I know where he's going to go with it. And I would have to go that way just based on what the law is in terms of enforcing a motion.
Yes, Your Honor. I think passing on today's hearing is what the court is telling me indirectly to do. So it definitely will pass on today's hearing. I'm happy to discuss with counsel on some sort of promissory note with secured by an agreed judgment. I don't know if that would be agreeable, and we would also ask that interest be paid on that, as there's been no interest accruing on this debt. And that's something that I would have to talk to my client about. Mr. McCullough has been patient and has been trying to be as amenable as possible, but he just wants to get paid for the services that he provided. And the court's initial order was kind of vague on how to enforce payment. And so we've been trying to comply with that court order while also seeking court intervention. But I'm happy to discuss with counsel about that as a potential possibility and talk to Mr. McCullough and see if that would be agreeable, or if we should find a new procedure and attack that way, Your Honor.
Okay, understood. Does everyone have their calendars out?
Yes.
Is there a certain date? Well, never mind. Based on what you all are doing, it would have to be on a Monday. Are there any upcoming Mondays that are issues for anyone?
Yes. Depending on what Monday, Your Honor.
Well, just tell me which ones you are not available.
Okay. Currently I'm not available on the 2nd or the 9th. Let's see. And in the 23rd. Trying to do some college visits.
Oh, I understand.
Not
So
for
the
me,
16th.
I'm a senior, yeah.
Okay, all right. And
Judge,
Attorney
I've got
Reed, Attorney Northam.
I'm sorry, Judge. I've got another enforcement hearing already previously set on the 16th.
Okay. So let's go to March.
Sorry.
No, that's fine. That's fine. I know everyone's schedules are different. Reed, you can chime in at any time. Does March 2nd, 9th, wait a minute, before I say that, the court's calendar too. Brittany, what do we have for March on Mondays?
Judge, on March 2nd, I'm set for a trial up in Lamar County, so I'm not available that day.
Okay, hold on one second. She was telling me. What did you say,
Oh,
Brittany?
sorry, Judge.
Okay, March 9th and March 16th. And you said you're not available when, Attorney Northam?
The 2nd, Judge. I am available
Okay.
on the 9th.
Okay. Is everyone available on the 9th?
I'm available on the 9th, but not the 16th.
I'm available on
Okay.
the 9th as well, Your Honor.
Okay.
Your Honor, I'm not available on the 9th. I'll be traveling for work in Central European time, so it'll be difficult for me to get on the call.
Okay. Okay, we have April the 6th.
I'm available on the 6th.
Okay.
Alicia
That
here.
works for me as well, Your Honor.
Judge,
All right,
I am
so
currently scheduled to be out of town, but I think I think I can make it work.
Okay. And with this hearing, correct?
Yes, ma'am.
Okay. So April 6th, since you're traveling, Attorney Northam, would a later morning be like 11 o'clock be better?
I don't know that matters, Judge. Whatever's convenient for the client with me.
Okay. Brittany, what about April 6th at 9:30? Okay. April 6th at 9:30, everyone.
And Judge, what's the purpose of the reset?
Well, that's just in the event. So I'm trying to accommodate. I'm giving
Yes,
you
ma'am.
all an opportunity to speak. If you work it out before then, you won't have that hearing. It'll go
Yes,
away.
ma'am.
Which is what ideally I think is going to happen, because if we were to come back, I don't see how we could really proceed with a hearing.
Yes, ma'am.
Yes, Your Honor.
Okay. All right. Is there anything further from anyone?
No, Your Honor.
That's all from us, Judge.
All right. Thank you, councils. I appreciate your time.
Thank
And
you for your
stay
time,
warm.
Judge.
Thank you, Your Honor.
You
Thank
too. May we be
you.
excused?
Yes, you're excused.
Thank you.
You're welcome.
Thank you, Joey.
Thank you.
Oh, you're welcome, guys. Have a good one.
Bye now.
Okay, so I stopped recording on that one. And now we are at, let me pull up your exhibits now. Hold on. And Attorney Pittman, Miss C. Strong was on, I don't know if you all had an opportunity to speak, but she was on my Zoom the entire time that you all were doing the exhibit conference with Judge Lee. So I just wanted to make sure, in transparency, I did lay eyes on her and speak to her that day. She missed because she was in mine.
Right. And the order to appear had both Zooms with different dates, so it might have been confusing. But Miss Seastrong did reach out to me via email and let me know that she had been in your Zoom. And I sent her the exhibits that Judge Lee and I had reviewed and admitted into evidence. 3 of them were hers and 1 of them was mine. So those are the exhibits that you have. You have 1 exhibit from petitioner and then 3 exhibits from respondent.
Okay, let me pull those up. I'm working with multiple devices here. So 2, 4, C Strong. All right, I have respondents exhibits 1, 2, and 3, and petitioners exhibit 1.
Yes. And
All
I
right.
sent those exhibits. I responded to Miss Seastrong's email and sent her those exhibits. They were in slightly different format than she had originally them to me, because originally it was just 1 PDF file and I broke them out into individual exhibits.
Okay, all right. You all ready to proceed? Well, before we begin, have you all had an opportunity to see if you could work out an agreement on this enforcement action?
We've had various communications and prior to my filing the enforcement, but I was clear that my intent was to file an enforcement. And since I have filed, we have not communicated, but it's a pretty narrow issue, Judge, that should just take a few minutes of the court's time.
Okay, all right. Both sides ready to proceed?
The movement is ready, Judge.
Okay, all right. And you're representing, is it Casey?
It's Casey. Yes,
Okay.
ma'am.
Right. Casey, I'm just going to add your last name, okay? I don't want to call you Casey. So,
Okay.
all right. Okay. Joy, you ready?
Yes, Judge, I'm ready. Go ahead. Thank you.
We're on the record in cause number DF 2418397. Counsel, will you please announce for the record?
Thank you, Judge, and I apologize. I'm in my home office, and when there's noise, my house Yeti gets upset about it. Marla Pittman, Your Honor, here representing Casey. Her last name actually is now Reyes, but she was previously C-Strong because she was married to Miss Denisha C-Strong.
Okay, let me make sure I correct that. My apologies, Miss Reyes. Okay, and Miss C-Strong, would you take yourself off of mute? I may have to send you a prompt. Hold on.
Okay, I got it.
Okay, I hear you. Would you please announce for the record?
My name? Denisha. Denisha C. Strong. Yes, ma'am.
Okay, and you are the respondent in this case, is that correct?
Yes, ma'am.
Okay, would you and Ms. Reyes please raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Thank you. Okay, we are set here today on a motion for enforcement filed by Ms. Reyes through her attorney, Ms. Pittman. Prior to going on the record, we had a conversation about some pre-admitted exhibits that will be admitted at this time. So petitioners exhibit 1 admitted and respondents exhibits 1, 2, and 3 are admitted. All right. And I am setting you all's clock right now at 15 minutes aside for your narrow issue. And that will include any opening and closing statements, should you all choose to make one, as well as any examination of any witnesses. Ms. C-Strong, since you are representing yourself, your sole witness may be only you, and you may choose to just call only yourself and tell me what you want me to know about your case. Just be mindful that you will also be subject to Attorney Pittman's objections, okay?
Yes, ma'am.
All right. Attorney Pittman, would you like to make an opening statement?
Yes, Judge. So the parties were divorced via an order signed by this court on June 30th of 2025. The sole issue that we're here, and I'll point out to the court that it was an agreed decree signed by both of the parties. The sole issue that we're here on today is a 2015 GMC Yukon motor vehicle. That vehicle and the debt was awarded to Ms. Seastrong. And the decree specifically stated that Ms. Seastrong should either sell, refinance, or otherwise pay off the loan of the vehicle within 30 days of the entry of the decree. That's because the vehicle loan is in both parties' names. And then in the decree, not only the assets, but then it's further clarified under debts that any debt associated with the 2015 GMC Yukon assigned to Ms. Seastrong. It also requires that Ms. Seastrong provide proof of sale, payoff, or refinance of the vehicle within 3 business days of that occurring. 30 days since the entry of the decree has lapsed, and we have not been provided any documentation of any refinance, sale, or payoff. In fact, Ms. Reyes can attest that the vehicle is still showing up on her credit report. I had some post-divorce communications with Ms. Seastrong, which are respondents number 1, some email correspondence that's already been admitted before the court. And we proposed that my client take the vehicle and either pay it off or refinance it. And Ms. Seastrong would not allow her to have possession of the vehicle until it was actually refinanced or paid off. So we filed this motion. We're asking for one of 2 things. Either she sell it and refinance it, or pay it off and provide proof to us that that's happened in pretty quick course, or that as soon as the roads are passable, Ms. Reyes pick up the vehicle and be responsible for the debt for either paying it off or selling it or refinancing it. Obviously, since these parties are divorced, there's very little trust between them. And so we hesitate to have any length of time if the vehicle is awarded to Ms. Reyes as part of our, in the alternative relief, for it remaining in Ms. Seastrong's possession. And that's all I have, Judge. It's a very narrow issue. We have also, of course, pled for fees for having to file a motion and have a hearing on this.
Okay, thank you, Attorney Pittman. Ms. Seastrong, would you like to make an opening statement at this time? And it's an opening statement, so it's not technically you putting on any evidence. It's more so of you telling me what your evidence is going to show. Or you can waive it. It's up to you.
Yes, ma'am. In the exhibits that I did show, I was between the emails between me and Ms. Pittman. I was trying to come up with a solution to resolve the car in the beginning. And so I wasn't able to do that on my part because the car was so upside down. It was worth more than the value of the car. And I tried to come to them with possible solutions of Casey trying to refinance the car, but they wanted me to give up the possession of the car with my name still on it. I let her know that I had just paid the other exhibits that I provided as well was the vehicle's in perfect standing. I'm not sure what's showing up on her credit, but it's in perfect standing. Again, I let them know that any positive solution to any of resolving this car, if she was to refinance in her name, I was more than fine with that. Except I didn't want to have her having the car under my name. So it's kind of the same thing, her taking the possession of the car, me not having my name on it because I'm still be on the car, on the vehicle. So it's I had in my exhibits, I guess, that Ms. Pittman threw out or objected to was where I went to refinance, tried to refinance.
And Your Honor, I'm going to object to that as to hearsay. And this is, again, this is opening, and that is not an exhibit before the court.
Okay, sustain. You can't reference an exhibit that's not before the court. And, as I stated to you, this is not evidentiary. This is more so you just telling me what your evidence will show. Because you don't want to go into testimony yet. This is just an opening statement.
Well, I did try to refinance the car. I wasn't on the other Zoom, so I didn't know that it was those exhibits were out. I apologize.
No, it's so you're representing yourself. So I know you may not understand the full process of it. Does that conclude your opening statement?
Yes, ma'am.
Okay. All right. Attorney Pittman, you may call your first witness.
Thank you, Judge. I will call Denisha C. Strong.
Okay. Go ahead.
Ms. C. Strong, state your name for the record, please.
Denisha C. Strong.
And you were previously married to Casey Reyes.
Yes.
The divorce decree was signed by the court on or about June 30th, 2025, correct?
Yes.
And you signed that as approved and consented as to both form and substance, correct?
Yes.
In that decree, you acknowledge that you were awarded the 2015 GMC Yukon, correct?
Yes.
And that vehicle has a debt associated with it?
Yes.
Is that
Yep.
debt held by Wells Fargo?
Yes.
And the debt, you and Casey were co-borrowers in connection with that debt, correct?
Yes.
The decree also assigns the debt associated with that vehicle to you, correct?
Yes.
The decree requires that within 30 days from the entry of the divorce, that you either sell, refinance, or otherwise pay off the loan of the vehicle. Is that correct? Is that what the decree says?
Yes.
Within 30 days of the entry of the decree, that would be approximately July 30th or 31st, 2025, did you sell the Yukon?
I did not.
Within 30 days from the entry of the decree, which would be for approximately July 30 or 31st of 2025, did you refinance the Yukon?
No, I was not able to.
Objection, non-responsive after no.
Sustain.
Within 30 days of the entry of the final decree, which would be approximately July 30th or 31st, did you otherwise pay off the loan of the Yukon?
No.
And with the answer to each of those questions, if I asked, did you provide documentation within 3 business days to Ms. Reyes of any of those acts, would your answers all be no?
I provided that I was not able to you and Casey.
So the correspondence regarding this matter was between me and you via email, correct?
Yes.
And we discussed, did we not? Well, you and Casey agreed on a mechanic, the vehicle, correct?
Yes.
And once the vehicle passed inspection, Ms. Reyes offered to take the vehicle and assume that loan, correct?
Yes.
And
Attorney Pittman, can I stop you right there? I cannot remember it swore them in.
You did, Judge.
Okay, thank you. It's being snowed in. I have snowed in brain. Okay, I
was having that discussion this morning with my husband about that snow day ADHD going on. So
yes, my apologies. Thank you.
Ms. Reyes agreed to take the vehicle and assume the note, correct?
Yes.
And you refused to allow her to take physical possession of the vehicle. Isn't that true?
With my name still on it, yes.
Objection, non-responsive other than yes.
Sustain.
Right now, the vehicle is in your possession and it still has Ms. Reyes's name on it, correct?
Yes.
Okay. And you provided documentation to the court. It's already been admitted into evidence. Your respondents number 2, which are the purchase documents from that vehicle, just reflecting that you and Ms. Reyes are both purchasers, correct?
Yes.
And then respondents number 3 is the payment record that you've been making in accordance with that note, correct?
Yes.
It appears that you printed the respondents number 3 payment record on January 15. However, the last payment reflected on that record is August of 25. Isn't that true?
I'm sorry?
The payment record, Judge, may I share my screen?
Yes, you may.
Let's see if I have what I'm looking for. Apologize, Judge. I've got to find the document. Ms. Seastrong, do you have the documents before you that I emailed to you? Your exhibits 1, 2, and 3? I found it. Here we go. Can you see the screen that I'm sharing? Ms. Seastrong, can you see the screen that I'm sharing?
Yes.
Do you recognize this as the payment summary that you submitted into evidence?
I had all the way up until January that I submitted.
Okay, I will represent to you that the only payment documents I received ended at August of 2025. Is it your testimony that the note on the Yukon is current?
Yes, the note is current as of today. Yes, all the way up until the payment. The last payment I submitted is January 18th.
Your Honor, I don't have any further witnesses for any questions for this witness.
Okay. All right. Typically, Miss C. Strong, well, never mind. Attorney, you may call your next witness.
Thank you, Judge. I'll call Casey C. Strong.
Okay.
Reyes, I apologize, Casey.
It's okay. It's the Snowden.
Casey, state your name for the record.
Casey Reyes.
And you were previously married to Denisha C. Strong?
Correct.
You heard the questions that I asked her about when the decree was entered and the contents of that decree. Do you agree that with her answers with regard to what the decree said?
Yes.
And as part of your negotiated agreed final decree, Ms. C. Strong was awarded the Yukon and the debt associated with it, correct? And how has the fact that Ms. C. Strong has not either sold, refinanced, or otherwise paid off the loan of the Yukon impacted you?
One, I did notice my credit take a dip. I'm not sure she says it's current, but my credit doesn't reflect that, as well as we are expecting our second child together. So I do need to be able to get a bigger car, and I cannot because that vehicle is still in my name. So I cannot, I do need a much larger car to fit all my children.
Did you retain me in order to file this enforcement action?
I had to. Ms. C. Strong was getting very aggressive in her emails, and I was not able to communicate with her. So that's when I had to retain you to even finalize the divorce.
And are you aware that I've had communications with Ms. C. Strong attempting to resolve this matter prior to taking the court's time?
Yes.
Now, our engagement letter says that you pay me for $350 an hour, correct?
That is correct.
And the exhibit P1 before the court are my two invoices reflecting expenses, including an estimated expense for today, totaling $1,616.75, correct?
Correct.
And the original invoice of $811.75 you have already paid, correct?
That is correct.
And that includes the expenses for filing the motion, getting the citation issued, and having the process server serve Ms. C. Strong. That's all included in the $1,616.75, correct?
Correct.
We've prepared an order for this court, and what we're asking for is in the alternative, either the court requiring Ms. C. Strong by a date certain to sell the vehicle and pay off the debt, or as soon as the roads are passable, perhaps close of business tomorrow, perhaps Wednesday, hard to tell with the weather, that you be allowed to take possession of the vehicle with the understanding that you would then be taking responsibility for the note, correct? And of course, it's been a while. Do you recall when we had that vehicle inspected? Was that in July or August?
Roughly around that time frame of last year. Yes.
Right. And if it is determined that there are any damages to the vehicle that were not apparent in the prior inspection, we would ask that Ms. C. Strong be held responsible for those damages as well. We just don't know as of right now. Is that correct?
That is correct. I just have the original vehicle inspection report from my mechanic.
I don't have anything further, Judge.
Okay. You may call your next witness.
Your Honor, I would just call myself as for fees. My fee statements are before the court. My name is Marla Pittman. I'm an attorney that have been licensed to practice law in the state of Texas since 1999. I just realized this is my 26th year. Approximately 17, 18 of those years have focused primarily on family law in the North Texas area. While I practice in many North Texas counties, I focus in Dallas, Collin, Tarrant, Denton. My hourly rate in this case is reduced based on the referral source. It's $3.50 an hour, which I believe the court recognizes as reasonable for Dallas County cases of this nature. Actions that are reflected in my unredacted fee statements are solely related to this action. There's no other activity recorded within those fee statements, and they accurately reflect the time that I have incurred in this case, which include attempting to negotiate a resolution with Ms. C. Strong prior to filing. My apologies. My fee statements do not include that. We tried to negotiate a resolution, and then I filed the enforcement, which is where the fee statements start. It also includes the Dallas County Court fees for filing the petition, issuing the citation, and my private process server fees for serving Ms. C. Strong. And I would pass myself as a witness.
Thank you, counsel. Could you give me that amount again? 1,000?
$616.75. It's the total of the two.
Oh, okay, I got it. And she's already paid $811.75.
Yes.
Okay. And the $1,616.75 amount, does that include an hour for today?
It includes 1 hour for today.
Okay.
I
Thank you,
included
counsel.
that in the second invoice as an estimated, but that, yeah. I wanted the
Okay.
invoices to try to be complete.
Understood. Thank you. Do you rest?
Yes, Your Honor.
All right. Okay, Ms. C. Strong, this is now your opportunity to call any witnesses that you may have. Like I said, you can call yourself. You can call yourself as a sole witness. You can also ask Ms. Reyes some questions. Just be mindful of the objections that Attorney Pittman could make, okay?
Yes, ma'am.
Okay. All right. Who would you like to call as your first witness?
Mom, Molly Aubrey.
Okay. Is she there with you?
Yes, ma'am.
Okay. Good morning, Ms. C. Strong. Is your name Ms. C. Strong too?
My name is Miss Ivory.
Could you spell that for me?
It's spelled Ivery.
Ivery. Ivory.
Yes, ma'am.
Okay. Would you raise your right hand for me, Miss Ivory?
Yes, ma'am.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. And is it Miss or Mrs.?
Miss.
Miss. Okay. You may lower your hand. Your daughter is going to ask questions of you, and you'll just respond truthfully, okay?
Okay.
Okay. And then after she's done asking you questions, then Attorney Pittman, if she has any questions, she'll ask you, okay?
Okay.
Okay. You may proceed, Miss C. Strong.
Yes, my mom, she was there with me all the places I went to try to refinance the car.
Objection, Your Honor. Relevance and hearsay.
Okay. Sustain as to, hold on, let me make my objection. Sustain as to relevance. So you have to actually ask her questions. You have to ask your mom questions. And remember, I told you Attorney Pittman can object.
Correct. Mom, were you with me when I went to try to refinance the vehicle?
Yes, I was.
And were you with me when I went through Mitsubishi and they told me that the car was upside down?
Objection, Your Honor. Calls for hearsay.
Sustain.
No,
You can't.
I heard it.
Hold on. So the person that you may have heard it from is not present. So you can't ask questions that would solicit her to say what someone else said.
Gotcha.
Okay. My mom, did she saw the exhibits that I presented
Yes.
showing proof of all the places I went to get the car refinanced?
Objection, Your Honor, referring to an exhibit that's not in evidence.
Sustain.
Your Honor, there isn't anything this witness I would object. There isn't anything.
Hold on, Miss C. Strong. One second. She's trying to make an objection. Go ahead.
I would object as to relevance. There isn't anything that this witness would be able to offer that wasn't hearsay based on the evidence that's before the court. She wasn't a party to the divorce. She's not a party to the transaction. And I would just object to any testimony from this witness.
Miss C. Strong, in response to her objection about any relevant information that your mother would have, how do you respond to that?
I actually have a question about the, because I wasn't on the Zoom. So with the exhibits that I provided, that Miss Pittman objected to, did I not have a say in the exhibits that I presented to the court?
So that's a different question. That's more of a question to ask me. I'm going to sustain her objection. So essentially what she's saying, the underlying court order that's between you and Ms. Reyes is
Mhm.
between the two of you. So anything that's in that court order, you and Ms. Reyes were ordered to do it. And because of that, anything that's outside of that does not go to the heart of the whether or not the Yukon was sold, refinanced, or paid off, it wouldn't be relevant to this type of motion. A motion for enforcement is very technical. So it's only talking about the underlying order itself. Does that make sense?
Yes, ma'am.
Yeah. So your in terms of your mother, she wouldn't necessarily be able to give any evidence to support why you didn't sell, refinance, or pay off
Oh, got it. Yes,
the
ma'am.
truck. Does that make sense?
Yes.
Well, thank you, Miss Ivory.
It's nice to meet you, Judge.
Miss C. Strong, you may call your next witness.
I'm sorry. That's the only witness I had, ma'am.
Did you want to call yourself as a witness?
Yes.
This will be your opportunity to tell me what you want to know. And again, the issues that were brought before the court in regards to the underlying order was whether or not you sold, refinanced, or paid off the GMC truck within 30 days. It's court ordered to do that.
Right. That's what, like I was saying, the exhibits that I provided, which I didn't know which ones that got received besides what Miss Pittman has sent me. The exhibits that I provided was showing, I had a whole bunch of exhibits of the places I went to try to get a refinance.
And I'm going to object, Your Honor. I recognize that Ms. Seastrong wasn't in the exhibit conference. However, I objected to those other exhibits as to hearsay, and those objections were sustained.
So I'm sustaining her objection she just made. Remember earlier I told you you couldn't refer to a document that was not in evidence?
Right. So I'm saying, like, the exhibits that I provided, I wasn't able to present my evidence.
Right. Because she objected to them, and Judge Lee sustained that objection, which means that they weren't brought into evidence, so you can't even refer to them.
Is there a reason why, if they would pertain to the car? Because they all pertain to the car of the different dealerships that and banks that wasn't able to refinance the car.
So the simple answer to that is because the law says I can't do it. The Texas Rules of Civil Procedure, they don't allow me to consider anything that's not evidence. You may proceed though.
Okay, so I did all I can. I was just trying to get positive solutions with this whole car. I don't have any objections to Casey taking the car, long as my name is not still on the car, as that's what she wants as well, not for her name not to be on the car. I've done paid more than half of the debt of the car. I did show that in one of the exhibits, like over 30,000. Now it's at 12,000. I can show the current balance that it's 12. Right now it's 12,600 that I owe left on the car. And in case I'm more than happy for her to take over the rest of the car, refinancing in her name, just long as my name is off, is what I would like to happen today. It's just me. I don't need that big of a car. I'm not fighting her on the car. I'm more than willing to give up the car as long as my name is not on it anymore.
So if I'm hearing you correctly, the two options were for you to sell, refinance, or pay off, or allow Ms. Reyes to take it over. Are you saying, with what you just said, are you saying that you're not opposed to the second option of Ms. Reyes taking it over?
No, I'm not. Yeah, I'm okay. I'm not opposing that. I'm more than willing to give her the vehicle as long as my name is not on the car anymore. I'm open to her just taking the rest of the amount due on the car by refinancing it in her name, because I wasn't able to do so.
So that means that she can pick it up whenever the roads are safe.
With what my name is still on the car.
Well, if you give it to her, then she will have to completely take it over, meaning that it would have to be refinanced, your name be removed off of it.
Right, but shouldn't she refinance the car first before taking possession of the car?
Well, it doesn't work like that, because in this particular situation, it was awarded to you.
Right.
So the court order as it stands is for you to do it. I can't change that. You and Ms. Reyes can agree to do something in the alternative, which is why Ms. Reyes today is asking that as an alternative. So in order to get her to take over the payments, you would have to give up possession of the car and let her refinance it. From what I'm hearing, it doesn't sound like she wants you to be on the car anyway when she takes it over.
Right.
And that's correct, Judge. The issue with my client taking the car was, as Ms. Seastrong just stated, she was refusing to allow Ms. Reyes to have possession of the car until she could show that it had already been refinanced, and that's not possible.
You understand that, Ms. Seastrong?
Yes. So, but what if she do take the car and she can't get it refinanced as well?
That's a good question, Attorney Pittman.
I can draft an order that would require sale of the vehicle if it can't be refinanced.
And how will I know?
Because the order will require us to provide you documentation, just like the decree required you to provide documentation.
And I'll sign the order. So that makes it official. All right. So, Attorney Pittman, did you have any questions for Ms. Seastrong?
Don't, Judge. However, my order that was previously submitted to the court does need to be revised. I originally thought that it would be an in-person hearing, so it has references to appearing in court, which obviously needs to be changed. And then I would propose that my client be able to pick up the vehicle by close of business on Wednesday, just to be sure that the roads are clear, and then allow her the same 30 days that Ms. Seastrong had to either refinance or sell the vehicle and provide that documentation to Ms. Seastrong through me. And the only other thing we would need is a ruling on the court with regard to fees.
So this is what the court is going to do. I'm going to give a little cushion just in case there are some, still slippery conditions on the road. And by Wednesday, I'm going to say by Friday. I think Friday would be the safest to do. So Ms. Seastrong, I'm ordering you to deliver possession of the vehicle to Ms. Reyes. Do you all know where, or is there a problem with you dropping the vehicle off to her home?
Our preference would be, Judge, they previously used a mechanic that they both trust. I think his name is Bobby. And
we can do that. So there's no issue. We don't want to create an issue where there doesn't need to be one. So whatever the address of Bobby, and we need his first and last name just for enforceability purposes, and wherever the address is, put that in the order. That's where you all will exchange the vehicle. Ms. Seastrong, you are ordered to bring any keys, paperwork that references the truck. You need to make sure that that is inside. I think the best thing to do is just put everything in an envelope and put it in the passenger seat. So it's right there. You turn the truck over, you leave, and then Ms. Reyes can pick it up. You all don't even have to see each other. Ms. Seastrong, did you have a question?
Yes, ma'am. With the insurance being in my name, how does that work? That she needs to provide the full coverage insurance on the car if I'm to have to drop the car, it drop my name off the car, insurance.
So I do know some insurance company, because I was able to do this. I was able to get insurance on the car the exact same day that I took possession of it. So whoever her insurance company is, that should be an easy fix. If she lets them know the information, if you provide her with the information for the vehicle, like I said, in the envelope, just leave it in the passenger seat. She can call her insurance company the same day and get the insurance switched over. So it'll come off of you and go to her.
So I don't have to drop the insurance on the car before Friday.
Well, no, because you're still in possession of it. So you wouldn't want to do that.
Okay.
Yeah, do not drop the insurance until you give up possession, because if anything happens to that car between now and Friday, you're going to be on the hook for it.
So what? Okay, I got it.
Yeah, okay. And then in regards to fees, I'm going to award the full amount of fees requested in $1,616.75. Unfortunately, when you have to bring things to court, this is one of the things when you bring issues to court, this is one of the things that you face. Ms. Reyes had to incur attorney's fees to get you here, and it really could have, from what I'm hearing, it really is something that could have been resolved outside of court. So I'm making you responsible for those fees. How much time would you need to pay that, Ms. C. Strong?
The amount.
Yes, ma'am.
I would need a little bit of time. I didn't know that I was going to be, responsible for the debt incurred.
And like I said, on any motion, really, when you come to court, you run the risk. If it was something that could have been resolved outside of court, you run the risk of being responsible for the other person's fees. And I can give you some time. You just, Attorney Pittman?
I was just going to say, Judge, that Ms. C. Strong was paying $465.56 a month towards the Yukon, and she will no longer be paying that note. And so there will be some extra money there to go towards fees. Just to point that out to the court, because my client will be taking over the note.
Okay.
I mean,
right,
that's your opinion. Like I said, even though, because the debt that I incurred on this whole divorce, I have more debt than that.
So Ms. C. Strong, to my question, how much time do you need?
Yes, ma'am. I do need more time to make the payment.
When you say more time, 40, give me a time. 45 days, 60 days?
60 days. Yes, ma'am.
All right. So today is January 26th. So let's just move it over to, I want to do it on April 1st because I don't want you for Fool's joke on Attorney Pittman. Okay. So we're going to do April the 2nd. That's when your fees are due. Now, that doesn't mean that amount you have to pay it in one lump sum. If you wanted to make a payment in February, if you wanted to make a payment in March, you can do that as long as the full amount, $1,616.75, is paid by April 2nd. You will still be in compliance with the order, okay?
Yes, ma'am.
And that needs to be by cashier's check or money order. So that way Attorney Pittman can have the receipt of it, and you can have a receipt for your records as well, okay?
And where do we be paid?
Yes, ma'am. And
you will make
I'll
it
be in the
go ahead.
I'm sorry, Doug. I was going to say that'd be set out in the order.
Yes, it will be in the order, but just so you know, it will go directly to Attorney Pittman. She will provide you with the contact information that you can make the payment to. And I think it was something else I missed. The refinance for Ms. Reyes needs to occur within 30 days.
Right.
All right. Is there anything further for the order? I mean,
that's all I have, Judge. Thank you.
Thank you all. And I'll be looking for that order, and Ms. C. Strong and Ms. Reyes, when I get it, I'll sign it. And then you all just do what you have to do on Friday. Okay. Thank you all. Stay safe. Be warm.
Judge. Are we
Thanks, Judge.
Are we excused?
Yes, you're excused. Yes.
State Court of Clayton County, Clayton County, Georgia, courtroom 304. This is the jail and arraignment calendar. I'm going to call the arraignment calendar first, and then we'll move to the jail calendar. This is the 10 a.m. calendar. First case on the calendar is Bria M. Carter. Bria M. Carter. Ms. Carter does not have an attorney present listed on the calendar. Is she present? Bria Carter. Ladies and gentlemen, I see iPhone listed on the calendar. It's almost impossible to assist you if your first and last name is not on the screen, because we have our calendars by first and last name. We're conducting business. So please make sure that you have your first and last name, not a nickname, not some other iteration, especially not iPhone, because everybody has one. So please make sure you go to the rename function for your first and last name on the screen for me. All right, today is July 14th, 2026. And once again, Bria M. Carter.
Because of bench warrant bond forfeiture.
All right, bench warrant bond forfeiture will be granted. Next is Corliss D. Collins. Mr. Holton Dennis? Mr. Lynch, I'm not hearing anything.
I'm here.
Who's that?
Corliss Collins.
All right. So, Ms. Collins, I need you to change. Do you know how to change your name?
I'm trying, and I do not see where to do it at.
Okay. All right.
Judge, can you hear me now?
I hear you
Yeah.
just fine now.
Okay. Judge,
Your
we'll
Honor,
do a conference with Ms. Collins.
Ms. Adams,
Yeah.
yes, ma'am.
I was going to say the statement's going to move to no press the Collins case.
All right, Ms. Collins, your case is being no pros. No pros means that they are not going to pursue prosecution of this case, so it's akin to a dismissal. Please, ma'am, be safe on the roads and make sure that your documents are in good working order and you are free to go at this time.
All right, thank you so much.
All right. All right, Andreas Cook.
Judge, she's
Jonathan.
present in the courtroom. I'm having him approach the podium.
All right. Mr. Cook, good morning. All right, so you're before the court for driving on a suspended or revoked license, count 1, no license, count 2, suspended registration, count 3, no tag or expired or invalid tag, count 4. Sir, did you wish to have an attorney represent you? Did you wish to represent yourself? How did you wish to handle your case?
I just wanted to say last week I went to the municipal court and they put me on probation for all those charges.
Okay, that might be another case. This is a 2023 case. So did you wish to have an attorney speak with you?
It's actually going to move to no process charge, this case.
All right, so Ms. Adams, the state has chosen to no pros the case, sir. So they're going to dismiss it, but just please make sure that you are not driving without your documents being in work order, okay?
Okay.
All right, thank you. Be safe.
You too. Thank you.
Yvonne Sheree Eccles. Ms. Eccles is present on video.
Judge, I just spoke with Ms. Eccles. I believe we're going to get that resolved. I just need to receive a document from her that I'm going to provide to the state, which is her valid license. And then I believe we'll have some type of a plea ready to go shortly after that.
Juanita Letitia Fluellen. I don't see them on the video and they're not responding from court. All right, bench warrant will be granted. Joseph Bernard Harden. Last call for Joseph Bernard Harden.
They request a bench warrant.
Bench warrant will be granted. Taisha Shatik Jones.
She's present, Judge.
All right. Ms. Jones, you're before the court for reckless conduct, and you also have a pending SSD, meaning that you have a suspended sentence where you were given extra time to pay on a previous case, and that's still pending. It has not been paid, so I just wanted to remind you of that. But for your reckless conduct case, did you wish to hire an attorney, represent yourself, or have an attorney appointed to you?
I can have one appointed to me.
Okay, so Mr. Lynch is in the courtroom. Either Mr. Lynch or Mr. Bug will speak to you about your case. And once they're able to give us some information about the case, then we'll determine whether it's going to move forward today or we'll have to give you additional information, okay?
Okay.
All right, you can have a seat. Next case is Deanna Orange. Last call for Deanna Orange. All right, bench warrant. Oh, go ahead, Ms. Adams.
No, they request a bench warrant. Thank you.
All right, bench warrant will be granted. So for the arraignment calendar, I have Carter, bench warrant bond forfeiture, Collins, no pros, Cook, no pros, Eccles is a possible plea, Fluellen, bench warrant, Harden, bench warrant, Jones is appointed, so that's a conference, and Orange is a bench warrant. All right, are we ready to move to the jail calendar, or do you need some time, Mr. Lynch?
Judge, I think we're still working through some of it. We're going to need some interpreters, but I think it would make sense to go ahead and call it because we do have some resolved at this point.
Okay.
Yeah.
No problem. All right, on the July 14th, 2026 jail calendar, first case on the calendar is Neri Aguilar Hernandez.
Judge, I believe we're going to need a Spanish interpreter to communicate with Mr. Aguilar Hernandez.
All right, so if we would ask one of the Spanish interpreters to log on or come down to the courtroom, that would be appreciated. So we'll have him in a few moments. Thank you.
It's been recorded. We took the way for him.
Deldon Artola.
Judge, that's the same announcement of confirmed he needs an interpreter.
Okay, Spanish interpreter.
Yes, Judge.
All right, Isaiah Kahim Bell.
Judge, if I'm not mistaken, Mr. Bell is not in custody. Can y'all confirm there's no Bell? Looks like.
Yeah, the state is going to move to no pros that one.
All right, Mr. Bell's case is being no pros. Jalen Tyler Cornwall.
Your Honor, this is Mr. Bug. We did
sir.
speak with Mr. Cornwall. I believe we may need an appointment order for his case unless the court already has us appointed.
Okay, go ahead and file the order and send the order and I'll sign it.
Okay, thank you, Your Honor.
Janine Desmond.
Judge, I think that person is not in custody.
Yeah, I think this
Yeah.
was the one
The
we talked
person-
about yesterday.
Yes,
So
ma'am.
she bonded out. She'll be put on another calendar.
If we have an open case in file, we do not need an appointment order because the application is not court. So why aren't we on the I don't know. It's been happening for years.
All right,
Your
next
Honor.
is, yes,
Desmond has been scheduled for September 10th at
okay,
1 p.m.
9, 10, 1 p.m. Thank you. All right, for Trepaniel Darrell Hardiman.
Judge, that's gonna be negotiated plea today.
Okay. Nathaniel Leyva.
Judge, that's also gonna be a negotiated plea today.
All right. Fernando Marin Garcias.
His counsel's here.
Okay. I think it's Garces. I'm sorry.
Good morning, Judge.
Good
Drew
morning.
Niner. Hi, good morning. Drew Niner for the Sperling Law Group. I'm here for Mr. Garces. I'm all but certain we have a negotiated plea. I just have to go over it with my client. Believe he will need an interpreter as well, but that should be a negotiated plea.
All right. So the interpreter should be in the courtroom pretty soon, or will be on video in order to assist, and we'll get it done. If she's on video, then you can sign in on your device, your phone, and use one of the conference rooms, and we connect y'all. We can connect y'all through, the video.
Thank you, Judge.
Thank you, courtroom judge. I totally was.
Oh, yes, she's coming to the courtroom. Never mind. Because we have enough where the courtroom's going to be easier for them, I think. All right. Next is Oscar Oriana.
Judge, I believe we are going to need an interpreter, and I'm going to verify whether we need an appointment order on that case as well, but we will need an interpreter. And I know she's coming. Thank you.
Okay. And then Bruce Ricardo Otoreyes.
That will be a negotiated plea.
And do they need an interpreter also?
No, he's fluent in English.
All right. Next is Kenneth Kushi Pack.
Judge, I believe Mr. Pack, I'm not sure if he's here. He was at a preliminary hearing this morning, and you're familiar with Mr. Pack.
Yeah.
If we can get him up here, then we'll make an announcement. If not, it seems he's got another matter pending in state court or holding him in jail.
All right. Well, if he comes up, we'll deal with it. Antonio Sherman Pierce.
Judge, I haven't spoken to Mr. Pierce yet. I'm not sure whether we are appointed on this case.
All right, I'll appoint.
All right, I'll talk to him.
All right, and Deshaun Robinson, that's a petition.
Judge, that's going to be a stipulation, and we're going to ask the court to accept the recommendation from Mr. Carmichael.
And Kristen Page Rohr.
Judge, I'm going to need to conference with Ms. Rohr.
Next is Cesar Ruiz.
Judge, I expect that we're going to get that resolved. We will need an interpreter, though.
All right, next is Ricky Hamilton Scott.
Judge, I believe that Mr. Moore may have submitted a proposed order for a mental health eval.
I did sign one.
Okay.
Is this for Mr. Scott?
Yes, Judge.
Okay.
And if we can address this case perhaps at the end of the calendar, I'm not sure whether we need procedurally, if there's anything else we need to do, but
if I sign the order, then we just hold the case until such time as we get information back.
Okay. Judge, could you resend the signed order to our office? We may not have a copy, or if we do, I'm not sure.
Yeah, I was having some technical issues with my tablet yesterday. So I'll resend it. I thought I had cleared everything that I signed, but I'll look for it. Mr. Moore, I think, was the one who sent it to me. So I'll look for his name and resend it.
Thank you, Judge.
No problem. Antoine Rashad Stanford.
Judge, that's a negotiated plea.
All right. Keaton DeLacy Styles.
Judge, I will need to conference with him and the state as well about what's going to be recommended by them to resolve.
Okay. Did you want to address anything now, or did you want to continue conferencing?
Judge, since we got two attorneys, if we could go ahead and do Mr. Robinson and run through a couple of these pleas that don't need any additional work.
Well, that sounds good. Let's go ahead and do the petition for Robinson, and then we'll do the pleas.
You got word that an interpreter's coming?
If you speak as this mic.
Gotcha.
All right. Good morning, Mr. Robinson. State of Georgia versus Deshaun Robinson, 2022 CR 06337. This is a petition for revocation of probation, and you're represented by Mr. Owen Lynch with the law firm of Lister, Holt, and Dennis. Sir, you're before the court for failure to avoid injurious and vicious habits. It's stated that you tested positive for alcohol on June 3rd of 2026. The lab confirmation came in on June 8th of 2026. You were before this court for DUI, alcohol, less safe. You were pled on the 18th day of May 2026, and you were sentenced to 12 months on probation. You have 10 months and 1 day remaining, and your sentence was not told. Mr. Lynch, what is going on with your client?
So, Judge, we understand the basis for the petition, and my understanding is that Mr. Robinson was forthright and honest about the fact that he had violated that condition. Judge, he understands that his probation prohibits him from consuming alcohol. I don't expect that you'll see additional violations from Mr. Robinson for that particular condition, Judge, but he does admit that he consumed and is asking the court to do.
Mr. Robinson, let's talk. So, yes, how old are you, sir?
36.
Where are you working?
South Atlanta Vascular Institute.
Okay. What you do for them?
Surgical tech.
Okay. Mr. Robinson. Okay, let's talk. You got a really, really good job.
Yes, ma'am.
Really good. And alcohol has ended you up in jail at least twice before me. Okay. So here's the issue. You're risking a lot. And if somebody told me that I would risk my really and time in the Clayton County Jail because I knew I wasn't supposed to drink, but I drank anyway, that would get me to start thinking that maybe I have an alcohol problem. Do you think you're an alcoholic, Mr. Robinson?
No, ma'am.
Let me tell you how I see it.
Yes, ma'am.
When you end up in an orange jumpsuit, when you have a conviction for DUI, when one of the things I tell you to do is, okay, you can't drink while you're on probation for this 12 months, because if you drink, that's going to violate your probation and you're going to come back. And then you drink and you come back and you're missing time off your job. You're in the Clayton County Jail, which is crazy enough right now to want to avoid it, but you don't think you have a problem with alcohol. It's a conversation, Mr. Robinson.
Oh, it was an honest mistake, Your Honor.
How so? What happened? Somebody handed you a Four Loko, or they gave you some punch and it just turned out to be rum punch? Like what was the mistake part?
Just having it in my refrigerator. And I mean, I no longer have it anymore, so
okay,
it's not gonna happen again.
You know what happens when people fail to realize that they have a problem? This behavior gets repeated. This is your first hearing. And a lot of times when people have DUIs, I expect that their first hearing is going to be because they tested positive for alcohol, because I suspect that the DUI is because you have an out of control relationship with alcohol. If you could control it, you wouldn't be back here risking your job as a surgical tech.
Yes, ma'am.
But then when you come before me, most people will say, oh, no, I'm good. I don't have a problem. Well, the desire to avoid acknowledging that you have a problem means that you're not going to deal with the problem. And then you're going to end up back here in front of me. Now, I don't know if you have any previous DUI history. I'm not going to look. I'm not going to ask. But if you think back into your mind about times when alcohol has been a problem for you, I can't imagine that this is the first time that you've had an issue with alcohol. Now, you may not have been caught by the police driving. You may not have been in jail on an alcohol-related offense, but you can think back to some times where you have overindulged and you probably shouldn't have in that situation. I don't know what's causing it, but I'm trying to get you to think so that you're not in this position again.
Yes, ma'am.
Just denying it and saying, oh, I've ended up before this judge at least 2 times. I've ended up in an orange jumpsuit at least 2 times. I'm missing time off work. I'm missing time at home. I'm missing time with my family. I'm jeopardizing a job that requires me to be efficient and technically compliant. But I'm going to still say, I don't think I have a problem with alcohol. I need you to think about that. Mr. Carmichael?
Yes, Your Honor.
What's the recommendation?
Yes, Your Honor. Probation is recommending that the defendant receive credit for time since date of lockup and to return back to probation with the same conditions.
Does he have a community support meeting requirement?
Let me double check, Your Honor. I believe the answer is yes. No, he does not. Would you like him to?
Yeah, we're going to add that, Mr. Lynch, that he attends 1 community support meeting for the cessation of alcohol or drugs per week.
I understand the court's requirements.
I'm sorry?
Judge, I understand the court's order, and I'll communicate. Mr. Robinson understands that I prepared him for this possibility. Should be able to do it.
How do we go about doing it?
AA meetings, they got them at churches and stuff. That's going to be the easiest one to find.
She said once a week. So how long?
Ongoing. So, but log some, and then you can talk to them about how long it's been. It's probably default the rest of probation.
How many days has he spent?
I didn't hear, Your Honor.
How many days has he spent in jail?
Yes, Your Honor. He was arrested last week on the 8th. So 7 days, Your Honor.
All right. So, Mr. Robinson, I'm going to order you to go to a community support meeting for the cessation of substance abuse. So that can be Alcoholics Anonymous, Narcotics Anonymous, or some other meeting with those goals. You will also report to probation that you have attended those meetings. You will not miss any meetings, or else we'll be back here and we'll be having a different conversation, okay?
Yes, ma'am.
All right.
That starts.
And Your Honor, may I speak with the defendant for a moment?
You may.
Hey, Mr. Robinson, can you hear me okay?
Yes, sir.
Would you like to report this upcoming Thursday or Friday? Thursday's good. What time would you like?
We can keep the 3:30 going.
Okay. Actually, I would need for you to come at 3. Is that
3?
okay? Yes.
I'll make it work.
Yes, sir.
Talk to them about that. There's probably some flexibility, but within the next couple of weeks, it needs to get started, or else it's going to be a problem.
Okay, so we're not going to see him Thursday start.
All right. So, Mr. Robinson, think about what I said, okay? You're putting a lot of stuff at jeopardy, and you need to figure out what is pushing you to risk a lot of things.
Yes, ma'am.
All right. Thank you.
You're welcome. Thank you.
And Your Honor?
Yes.
That was my only case. May I be excused?
Yes, sir. Thank you.
Thank you, Your Honor. You have a good day.
You too.
State suspend the fee. I just know sometimes I can't. So that's why I asked. I always can't. My understanding is they can't. Your Honor, may I make an announcement?
Yes, Mr. Bug.
Good morning. We're ready with Pierce for a plea of nolo for the no license.
Okay. Bring him up.
Brought out? Okay.
Yeah. Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus sorry, I think I got the wrong one. State of Georgia versus Antonio Sherman Pierce, 2026 CR 06424 for no license. Mr. Pierce, you're represented by Attorney Wesley Bug, who's with you at the podium. Mr. Bug, what is your client plead to the offense before the court?
Nolo, Your Honor.
All right. By entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on this or your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis recommendation. I'll accept a stipulation.
Thank you, Your Honor.
All right, recommendation.
Your Honor, the state is recommending a $500 suspended fine.
All right, $500 fine suspended for time served. Mr. Pierce, when we gonna stop meeting like this, sir? Well, this ain't our first meeting, right?
Your Honor, I do apologize. We're gonna ask that Mr. Pierce not be questioned at this time, Judge,
Okay.
considering what he's got going on.
Okay, I didn't know what he has going on anywhere else. I just know what he has had going on in front of me.
I
And I need
understand, Your Honor, but your question
Mr.
is
Pierce, you don't have to answer any questions that I ask you, but I do want you to consider that you got to start making some better choices for yourself, okay?
Yes, ma'am.
I just want you to do that. All right?
Yes, ma'am.
Okay, you can go back with the sheriff's office. Your case is concluded. All right, who's next?
Your Honor, we're actually ready to go forward with the negotiated plea off the arraignment calendar for Miss Eccles, unless you want to keep doing inmates.
I will do whoever y'all are ready for.
We're ready for a plea from Miss Eccles. Can you turn on your camera, please?
This is a new no license? Never mind. Yeah, Miss Eccles.
There she is.
I'm sorry.
No worries. I was about to text you.
No problem with what we got here. All right, Ms. Eccles, you're before the court on State of Georgia versus Yvonne. Is it Yvonne?
Yvonne, yes.
Yvonne Sheree Eccles, 2024 CR 11139 for speeding, count 1, and no license, count 2.
Yes.
Mr. Lynch, what is your client plead to the offenses before the court?
Judge, she's going to enter a NOLO plea to the speeding charge, and the state, I believe, is going to null pros the license charge due to her having a valid license at this time.
All right, by entering a plea of NOLO to speeding, and the license charge will be no pros, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself, and if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis recommendation.
Your Honor, on February 5th, 2024, at approximately 1:12 p.m., officers were conducting traffic enforcement on Tar Boulevard near its intersection with North Main Street in Jonesboro, Georgia, and that's in Clayton County, when they observed a black 2021 Nissan Versa traveling at a high rate of speed. The officer visually estimated the speed to be approximately 65 miles per hour, and then using his county lidar, he detected the vehicle to be traveling at 63 miles per hour in a 45 mile per hour zone. As to count 1, the state is recommending a $100 fine.
All right, so the fine is $100 with the surcharges from the state. It'll be $153 total. Ms. Eccles, did you wish to have more than 30 days? Because you're not at the courthouse, I give you 30 days automatically. Did you need 60 days or did you wish to pay it within the 30 days?
Can I have 60 days just in case I can't pay it in the 30?
Yes, ma'am. So the next thing I'm going to ask you to do is to send your email address. Do you know how to use the chat function?
Yes, ma'am.
Okay, so what I need you to do is go on to chat, go on to new chat, and you're going to choose April Heddens.
Okay.
Send her your email, your first and last name and your email address.
Yes, ma'am.
She's going to send you your sentencing sheet. It's going to have the exact date by which you need to pay. Please pay on or before that date, or an arrest warrant could eventually issue for you. Okay?
Yes, ma'am.
All right. You can also, in the instructions, will also be information about how to pay online or by phone.
Okay.
All right. Thank you so much.
Thank you.
All right. All right. I think the only remaining case on the arraignment calendar is Jones, which was an appointment.
Yes, Judge. Judge, I'm going to speak to her next. I think we just got the paperwork.
Okay, that's fine.
For Ricky and any way for you. These are in our email as well, right? Yeah. Can you save just this paperwork? Yeah. And then email that to Justin Moore?
Gotcha. And you just asked for a mental health stuff?
He's expecting this paperwork, so you don't need to say anything. Just say accusation.
Should I do it in Word, but in the shelters?
Yes, ma'am.
I think something's over there. I'm pretty sure I put something over there.
Your Honor, we're prepared to move forward with Stanford if the court will allow.
All righty.
Deputy, can I get Stanford out here, please? Yes.
All right, Antoine Rashad Stanford, I'm ready.
This is resources.
All right, sir, raise your right hand for me.
Over so she can see.
Yeah, thank you. Mr. Stanford, raise your right hand for me. I see it. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down. So, Mr. Stanford, you're before the court on State of Georgia versus Antoine Rashad Stanford, 2026 CR 06422 for criminal trespass. You're represented by attorney Mr. Bug, who's with you at the podium. Mr. Bug, what does your client plead to the offenses before the court?
No, Your Honor.
All right, by entering a plea of nolo to criminal trespass, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
Factual basis recommendation, please.
Your Honor, defense will stipulate if the court would allow.
I need to hear it so that I know if there's anybody who needs to have no contact.
Understood.
All right, go ahead, ma'am.
Yes, Your Honor. On June 23rd, 2026, officers on directed patrol at the Atlanta airport located at 6000 North Terminal Parkway, Atlanta, Georgia, in Clayton County, observed the defendant approaching passengers asking them for money. The officer approached the defendant and asked if he was flying out, and the defendant stated no. The officer asked the defendant if he paid for the bag of candies, and he stated no, he stole it. And then the officer then detained the defendant. As to count one, the state is recommending 12 months to serve, 20 days, credit for the time served.
I'm sorry, your voice went out on the day served.
I'm sorry, Your Honor, 20 days.
Okay.
Credit for the time served. The balance will suspend as long as the defendant does not return to the incident location unless he's ticketed and unless he had no new violations of law.
All right, Mr. Bug, anything from you about your client?
Your Honor, I've shared with Mr. Stanford a list of resources. He hopes to enter into a program where this type of behavior won't come up again. So he would like to accept the state's offer at this time.
All right, Mr. Stanford, Mr. Bug has given you some information, sir, that might help you avoid this. They're cracking down at the airport. So anybody who's not ticketed or who's not working there, they're calling the police and they're having you arrested. So please be careful. See if there's some help on that page that Mr. Bug gave you that can help you kind of get back. Because it's hard when you come out of jail, especially if you don't have somebody who's there to assist you. So check that out, make some phone calls and see if you can get back on your feet, okay?
Yes, sir.
All right, so 12 months to serve 20 days credit for time served, balance suspended, so that you, as long as you do not go back to Hartsfield-Jackson Atlanta International Airport without a ticket for travel on that date, or work, and as long as you have no new violations of the laws of the state of Georgia. All right, you can go back with the sheriff's office.
All right, thank you.
Thank you. All right, so I didn't know who else was ready. I know we're still waiting on the interpreter, so I'm not sure if this is going on or a prelim downstairs. Sometimes that can take a little while.
I'm about to check on them now, Judge.
All right. Oh, here she is. Oh, Miss Bermudez, just in time. So, Miss Bermudez, we got you loaded up today. I think we have 1, 2, 3, 4, maybe 4 or 5 people for you to talk to.
Yes.
So we'll take them whenever y'all are ready.
I believe, well, he just stepped out. I believe that Mr. Garce's case is ready, but the attorney just stepped outside.
Okay, that's fine.
Yes, it is ready.
Could you help me with a few, please?
All right, so Mr. Bug, Mr. Lynch, y'all know the drill. Prioritize Miss Bermudez so we can get her to another court if she needs to.
Yes, Your Honor, we're on it right now.
Thank you.
Okay, yeah, I'm in a Zoom too right now that just got called. But yeah, let's go ahead and do it.
Your Honor, this is Attorney Drew Niner. I am ready on Fernando Garces whenever the court is ready.
I'm ready.
I just need him to get brought out.
Okay. Garces.
Buenos días, señor Garces.
Buenos días.
Good morning.
Sir, you're before the court on State of Georgia. One second. State of Georgia versus Fernando Marin Garces. Your attorney, Mr. Niner, is with you at the podium.
Niner está con usted en el podio.
This is case 2026 CR 06612. You're before the court for simple battery family violence.
Simple violencia intrafamiliar.
Count 1.
Cargo número 1.
Simple battery. Count 2.
Simple cargo número 2.
Cruelty to children. Counts 3 and 4.
Cargo número 3 y 4.
Mr. Niner, what does your client plead to the offenses before the court?
So, Your Honor, we spoke with the state. Our understanding is that we're going to be pleading to an amended charge of a county ordinance disorderly conduct.
And that's going to be count 1.
I'm sorry?
Well, I was just saying that was count 1, Your Honor.
Okay. All right.
I'm sorry, Your Honor. The interpreter didn't get what Ms. Adams just said.
I just said that was count 1.
Thank you. Yes,
Mr. Garces, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do swear.
All right, you can put your hand down.
Okay.
And Mr. Niner is for the county ordinance, is that a guilty?
It's a no-lo, Judge.
Okay. By entering a plea to count 1, the amended charge of county ordinance violation, disorderly conduct, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
Factual basis and recommendation. Interpreter speak, please.
On April 26, 2026, at approximately 10:45 p.m., officers responded to 6440 Boca Raton Court, Forest Park, Georgia, 30297 in Clayton County in reference to a domestic disturbance. Upon arrival, officers made contact with the defendant, who stated that he and the victim's name is Yasmin Marin, YAZMINMARIN. He stated that he and the victim were living together, but they're not currently together. He stated that he and the victim were arguing verbally, and the argument continued into their daughter's room, where he tried to get their daughter's cell phone because there was footage and information on the cell phone regarding the victim talking to someone else. The officer then made contact with the victim, who stated that during the verbal altercation, the defendant got angry and grabbed her shoulders, trying to push her around. She pulled away from the defendant and started to walk away when the defendant put his arm around her neck and pulled her backwards in an attempt to try to make her fall down the stairs. The victim was able to grab the railing to prevent herself from falling backwards.
Recommendation.
As to count 1, the state is recommending 6 months to serve 30 days. Credit for the time served. The balance will suspend as long as the defendant has no contact with the victim, Yasmin Marin, and as long as he has no new violations of law.
Mr. Niner, do they have children together?
Yes, Judge.
Is there a plan for how these children are going to be supported with a no contact order?
apoyados o mantenidos si no puede haber contacto entre ellos?
Full disclosure, part of our biggest concern here is that he does have an ICE hold. That's a big part of why we reached this resolution.
I got you.
First things first is we're trying to get that squared away, kind of taking things one at a time. We just got this resolution today. They do have other family members in the area. They're going to have to make it work.
Okay. Mr. Garces, I know there are some things where you just can lose your head, but first of all, you can't make somebody be faithful to you or stay with you. If you suspect they're cheating and you start looking through their phone, that relationship is already over. Anytime you lose trust in somebody to the point where you got to go through their phone, that relationship's done. The best thing is to square yourself away, co-parent your children, get some help for the heartache, but don't put yourself in a position where you lose everything you're trying to build. You know what the consequences are. We clear? All right. So I'm going to accept your plea to county disorderly, 6 months, 30 days credit for time served. Balance will be suspended as long as you have no contact with Yasmin Marin and have no new violations of the laws of the state of Georgia during the 6 months. All right? Thank you, sir. You can go back with the sheriff's office.
Of course.
Okay.
Your family will be in touch with my office. Okay.
Yes, sir.
How do we go about getting a copy of that disposition?
Go down to the second floor, the traffic court window, they can print you one.
Okay. Is it usually ready now?
Yeah.
Okay. Thank you,
They'd
Judge.
be able to print you one and they can just put my signature on file because they haven't sent it to me.
Thank you, Your Honor.
You're welcome.
Your Honor, I have an announcement off the arraignment calendar or the OTB arraignment calendar.
All right.
Judge, Miss Tyasha Jones, on the case that's pending today, the reckless conduct case we just got appointed to, she does wish to enter a not guilty plea today, and we can waive formal reading. Judge, I was told she has a pending SSD. I did look up that case. She did state that she is able to pay that in full today if the court would. I don't know if anything needs to happen to make that.
She can go downstairs to the second floor to the traffic court window and she can go ahead and pay it today. And then there'll be no further consequences.
And you're able to make that happen? Okay, she's gonna just go ahead and take that.
All right, and then she'll just wait for notice in the mail for her next available court date.
Absolutely, Judge.
All right, so that concludes the arraignment calendar.
So did she enter not guilty for this case, Judge?
That's my understanding, Mr. Lynch, correct?
Yes, Judge. Yeah, yes, Ms. Bell.
Yes, so she has a not guilty. Also, please remind her of her bond conditions.
Yes, Judge. Actually, I don't think it's going to be possible for her to violate that condition. But
What was that for again?
For Tyasha Jones on the arraignment calendar.
Thank you.
So that will be the last active case on the arraignment calendar. And now we're back to jail.
Excuse me, Judge, what were
Yes.
counts 2 to 4 on the Garces case?
Counts 2, 3, and 4 were null pros.
Thank you, Judge.
Count 1 was amended.
Judge, we're ready to go forward on a plea for Mr. Hardiman. I think Mr.
Okay.
Bug.
Y'all also have Leva who's ready too.
Yes, Judge.
Okay, I'm ready. Raise your right hand for me, Mr. Hardiman. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court on 2026 CR 06615 for no license, count 1, speeding, count 2, DUI, alcohol per se, count 3. Mr. Lynch, what is your client plea to the offenses before the court?
Judge, it's going to be guilty pleas to all 3 counts.
All right. By entering a plea of guilty to counts 1, 2, and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
Factual basis recommendation, please.
Your Honor. On June 26, 2026, officers on routine patrol on Tower Boulevard and Highway 138 in Clayton County observed a 2008 Ford Crown Victoria traveling on the roadway, rapidly accelerating and changing lanes. Eventually, he observed the defendant traveling 72 miles per hour in a 45-mile-per-hour zone. Based on those observations, the officer then initiated a traffic stop and made contact with the defendant. Officer observed a moderate odor of alcoholic beverage emanating from the defendant's person. He observed that the defendant's speech was slurred and that the defendant had bloodshot red eyes and a flushed face. The officer then requested that the defendant perform standardized field sobriety testing, to which he agreed. The officer performed those tests and the defendant performed poorly. The officer read the defendant implied consent, and to which he agreed for blood. And then the BAC, I'm sorry, I don't have that with me. Oh, he didn't even get blood, excuse me. The officer read implied consent and originally he agreed for blood. But later on, the defendant was adamant that he wasn't under the influence and he requested a breath test to prove it. The officer then reread the defendant implied consent for breath and then the defendant agreed. At that point, officer performed the portable breath test and the test indicated a BRAC of 0.114. Additionally, as it relates to the no license charge, the officer determined that the defendant did not have a license during the interaction and additionally charged him with no license for driving on Georgia roadways with no license. As to count one, the state is recommending a $1,000 suspended fine. This is his second arrest in 5 years for the no license charge. As to count two, the state is recommending a $150 suspended fine. And count three, the state is recommending 12 months to serve 1 day. Credit for the time served. The balance will be probated for the defendant to pay a $300 fine, complete 40 hours of community service, complete a risk reduction program, complete a substance abuse evaluation and follow any recommended treatment. And the defendant is to have no drugs or alcohol and he is subject to random screenings and tests.
Mr. Lynch?
Judge, I am asking the court to accept the plea as negotiated.
Mr. Hardiman?
Yes, ma'am.
You gonna drive with no license, then you're gonna speed, then you're driving under the influence. Did you not think you might attract attention? I'm just really confused. So this is your second no license. The third one, I'm sure, as Mr. Lynch has told you, is going to be a $1,500 fine. The fourth one will be a felony. Now, it would be horrible to get a felony on your record for not. The second thing is, if you don't have a license and you know you're not supposed to be driving, why would you run the risk of attracting attention by being under the influence of alcohol and speeding? And if you don't have a license, then you don't have insurance. If you don't have insurance and you hit somebody, you maim or kill somebody, then there's no way of the family of that person being compensated because you don't have insurance. And I don't know if you have sufficient personal funds, you could be rolling like that. But I don't know if you have sufficient personal funds to at least compensate them for the injury or loss that you would have caused. Now, I want you to think about it this way. If your mama was in a car and somebody hit her and caused her to lose her life or caused her to have significant injury, and then you found out not only were they driving with no license, but they were also impaired, and this was not the first no license charge, this was a subsequent one, how would you feel about that? So don't do that to somebody else. Don't do that to somebody else. All right, so I'm going to accept your plea of guilty to counts 1, 2, and 3. I'll sentence you on count 1 to a $1,000 fine suspended for credit for time served. Count 2 will be a $150 fine suspended for credit for time served. And count 3 which will run concurrent with counts 1 and 2. 12 months to serve 1 day, credit for time served. Balance will be probated for you to pay a fine in the amount of $300. It's going to have surcharges. They're going to be expensive. 40 hours of community service, a risk reduction course, substance abuse evaluation, and any treatment that may be ordered by the evaluator. You're to have no alcohol or illicit drugs. Now, see, people think that they're going to skip the test and going to catch it, or we're not going to find it, or you're not going to get that random test right after. But, sir, no alcohol, no illicit drugs. We clear? All right. And you're subject to random screens for alcohol and drugs. Now, the quickest way to get rearrested is to fail to attend your probation reports, because if you don't show up for probation, I will definitely get an arrest warrant and I will sign it. If you have any difficulty completing any of the special conditions of probation, please talk to your probation officer and they will assist you in order to help you be successful on probation. But if you don't tell them, they won't know. They can't help you. Got me? All right, you can go back to the sheriff's office. All right, y'all had a plea. My understanding was for Leva.
Yep. Can y'all pull Leva next?
I did find the Scott order and I sent it. I thought I had signed it, but maybe it didn't go through before, so I sent it again.
Thank you, Judge.
So Scott can go back, is my understanding. Has Mr. Pat come up from prelims?
Judge, the deputy just stepped out to grab Mr. Leva, but I'll
Okay.
ask about that.
No problem. All right. Is this Mr. Leva?
Yes, ma'am.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So, Mr. Nathan U. Leva, you're before the court on 2026 CR 06616 for no license, count 1, no tag light, count 2, no tail lights, count 3, headlights covered, count 4. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, he's going to plead guilty to count 1. I believe the remaining charges are going to be null prost.
All right. By entering a plea of guilty to no license, count 1, counts 2, 3, and 4 will be null prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Leva?
Yes, ma'am.
All right. Factual basis recommendation, please.
We don't mind stipulating that he didn't have a valid license at the date of the stop.
Okay, that's fine. Recommendation.
Yes, Your Honor, the state is recommending a $500 suspended fine in consideration for the time he spent in jail.
All right, Mr. Leva, I'll accept your plea of guilty to count 1, $500 fine suspended for credit for time served. Counts 2, 3, and 4 will be null prost. Sir, if you're driving without a license, it's too easy for them to figure that out. All it takes is a tag reader. And once they start there, it's too easy to figure out you don't have a license. And then he went into tag light and head, tail. I mean, all of this. You got me?
Yes, ma'am.
Get your license, man.
I will.
All right. You can go back to the sheriff's office.
Thank you. You want to bring out Otero next?
Okay. So we still have Aguilar Hernandez, Artola, Cornwall, Oriana, Ortero Reyes, Pack, Rohr, Ruiz, and Stiles.
Yes, Judge. And they're bringing out Mr. Otero right now for his plea. And
Okay.
Mr. Bug is speaking with an interpreter to some of all the other clients in need of the interpreter.
Yeah, that's fine. So Mr. Otero Reyes is fluent in English. So once we do his, if you all want to break to do conferencing, that's fine.
That's what yes, Judge.
Okay. All right. This is case 2026 CR 06613 for Bruce Ricardo Ortero Reyes. Mr. Ortero Reyes, you're before the court for criminal trespass with damage to property. You're represented by attorney Owen Lynch, who's with you. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. You can put your hand down. Mr. Lynch, what does your client plead to the offense before the court?
Judge, he's going to plead nolo today.
All right, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right. Factual basis recommendation, please.
Your Honor, on April 23rd, 2026, at approximately 1:10 p.m., officers responded to 6589 Highway 85, Riverdale, Georgia, 30274 in Clayton County in reference to a disturbance. Upon arrival, officers observed that the business, the Riverdale Lodge, had 2 front windows shattered. The officer then made contact with the complainant, who was an employee of the Jiffy Lube Auto Shop, which is situated next to the Riverdale Lodge. And the complainant advised that he heard someone yelling and then he heard glass shatter. The complainant advised that he had went to see what caused the noise, and he saw the defendant kicking and destroying the windows of the Riverdale Lodge. The defendant, the complainant advised what the defendant was wearing, and the officer made contact with the defendant and observed a cut on the defendant's right hand and blood around it. At that point, yes, he was taken into custody. The officer detained the defendant. As to count 1, the state is recommending 12 months to serve 30 days. Credit for the time served. The balance will suspend as long as the defendant does not return to the Riverdale Lodge, or it's formerly the Riverdale Lodge. It's no longer in business anymore, but to the business located at 6589 Highway 85, Riverdale, Georgia, 30274, and as long as he doesn't have any violations of law.
Mr. Lynch, anything on behalf of Mr. Otero Reyes?
Judge, we've spoken about this. I am asking the court to accept the recommendation. I think Mr. Otero expressed that he needs to find some better ways to deal with some of the issues that he's dealing with. And he's going to try, I think, to reunite with some family and to try to get himself on a better path. But
how old are you, sir?
I'm 24 years old, Your Honor.
Mr. Otero Reyes, your life is just starting, but it will go quick. I vaguely remember being 24 years old, but it went fast. And so what I'm telling you is you got to get a hold to things now. If you don't get a hold to your life now, and you're doing destructive stuff like this, because this didn't have to happen. You could have cussed and punched the air and still got the same effect without going to jail.
3 months ago, wishing I one time, you know, I definitely listen. And I actually been doing courses. I actually forgot my paper. So you can check the EDOVO.
Yes.
I actually learned that when I get quick angry, I learn how my body reacts. And I never really think about stuff like that. I learn how my body reacts. My heart will race, or I'll be quick to jump to think instead of just slowing down. Being here, I definitely me to just slow down. And on top of that, it's just I was into my other inmates, like it could have led me to do something else worse out of anger. So
Mr. Otero Reyes, you are learning some very valuable lessons. Let's hope that these lessons stick with you and you put them into practice, because you're too young to waste your life on stupid stuff.
Yes, ma'am.
What I need you to do is, once you get out of jail, I need you to sit down with a piece of paper and a pen. And I want you to come up with 5 things that you want to accomplish in the next year. 5 things. They can be big things, they can be small things, but you have to set your intentions, because if you are just out here winging it every day, this is what happens. But if you set your intentions and you work towards those intentions, then the universe has a way of kind of like putting things in path that will help you. Okay? But you can't just go out and be destructive because something didn't happen the way you wanted it to happen. And I know that you say you are getting help recognizing patterns and things and avoiding that, and that's a good thing. But the next step is to have a plan for your life. Even if everything that you put on that list doesn't come true, there will be other things that happen that are good for you because you had some intention. Does what I'm saying make sense?
At this point, since I was thinking, yes, ma'am. I was thinking if my not bad, I can join the military, knock out 4 years, and
Well, that's an, but all I ask is that whatever your next moves are, make sure they are intentional. And usually that happens if you start thinking about stuff and writing it down. Okay? All right. So I'm going to accept your plea, 12 months, 30 days credit for time served. The balance will be suspended as long as you do not go back to that address at 6589 Highway 85, Riverdale, Georgia, and you have no new violations of the law. You understand?
yes, Your Honor,
All right, Mr. Reyes, I want to see some good things from you.
you will.
All right, take care.
Okay, Judge, if we could just have a few minutes conference and we'll be back.
Yeah, that's fine. Y'all just let me know when you're ready. I'm coughing, so I'm gonna go grab some tea, and I'll be right back.
Your Honor, we're prepared to move forward with several inmate cases when the court will allow.
I am ready.
Okay. Can we start with Mr. Oscar Aurelia?
All right, Mr. Oscar Oriana, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give will be true?
I do swear.
You can put your hand down. You're before the court on state of Georgia versus Oscar Oriana, 2026 CR 06567 for battery family violence count 1, battery count 2, simple battery family violence count 3, simple battery count 4. Mr. Bug, what does your client plead to the offenses before the court?
Your Honor, we would plead guilty, but we would like to do so under Alford v. North Carolina, and I can provide more facts.
You said guilty under Alford. You need to move closer to the Miss Bermudez is position fine. You just need to move closer to the red microphone.
Alford v. North Carolina.
Okay, and he's entering an Alford plea to which charge?
Count 1, Your Honor.
Okay, counts 2, 3, and 4 will merge.
That's my understanding.
Factual basis and recommendation, please. Oh, I'm sorry. One moment. Mr. Oriana, by entering this plea under Alford v. North Carolina, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
Factual basis and recommendation, please, Ms.
Yes, Your Honor. On June 4th, 2026, at approximately 7:48 p.m., officers were dispatched to 6311 Murphy Drive in Morrow, Georgia, and that's in Clayton, Georgia, regarding an incident that occurred at the Bloom Apartments, located at 6252 North Lee Street, Morrow, Georgia, 30260. And that's in Clayton County. Upon arrival to the location they were dispatched to, Officers made contact with the victim, Blanca Estefani Flores Cardona, and I'll spell that for you later, Your Honor, who stated that the defendant and her were seated inside of the car when he began striking her. The victim stated that the situation was an ongoing domestic violence issue, and she stated that she is tired of those circumstances and wanted to leave the situation but did not know what to do. Officers observed bruising on the victim's arms, legs, and face. And when officers made contact with the defendant, he stated that he only tried to get the victim back in the car. Ready for the recommendation, Your Honor? The state is recommending 12 months to serve, 30 days, credit for the time served. The balance will be
Can you repeat that, Ms. Adams, for the interpreter?
Yes, 12 months to serve, 30 days, credit for the time served. The balance will be probated for the defendant to pay a $300 fine, complete 40 hours of community service. And I'm not sure if you communicated this, Mr. Bug, but complete a FVIP course.
I did share it with them, but it's
Okay. And he's to have no contact with the victim, Blanca Flores, and her name is spelled Blanca Estefani, Estefani, Flores, Flores, Carolina, Carolona.
Mr. Bug?
Yes, Your Honor. As mentioned in the police report, the two involved parties were in a vehicle, and at some point, the alleged victim tried to leave the vehicle while the vehicle was moving. The defendant did not want her to harm herself, so he attempted to restrain her so that she would not leave the moving vehicle. And then soon after, quickly moved and parked the vehicle to allow her to leave, to not escalate the situation. So that is why we are asking for the Alford v. North Carolina. I do believe there may be either a defense of property or a defense of self argument, but the defendant in this case would like to resolve the case today and is willing to do the family violence class. Therefore, we're asking that the court accepts the negotiated plea under the Alford v. North Carolina doctrine.
Mr. Oriana? If somebody is willing to jump out of a moving car to avoid contact with you, something is seriously wrong. If somebody doesn't want to be with you to the extent that they would risk their life to get away from you, then you got to think that maybe you're the problem. Even taking what you say is true, this woman was willing to risk her life to jump out of a moving car to get away from you. I'm going to accept your plea of guilty under Alford v. North Carolina to count 1. Count 2, 3, and 4 will merge. I'm going to sentence you to 12 months to serve 30 days, credit for time served. The balance will be probated for you to pay a fine in the amount of $300, which will be $444 with the surcharges, 40 hours of community service, a 24-week family violence intervention program. If you miss or are late for more than 3 classes, they will make you start all over again. And you're to have no contact with Blanca Estefania Flores Cardona. And that means...
I am so sorry, Your Honor. I do have a note that they share children and that she would like contact for that reason only.
That you can do that through the court.
Okay, thanks.
You can go through the Superior Court. You can pay child support. You can mail the payment to the address, but there shall be no other contact other than you paying for your children. If you all get something through the Superior Court regarding custody or visitation with the children, then you can follow the Superior Court's order, but you're to have no contact with Miss Blanca Estefania Flores Cardona. And if you're not married to her, or have not legitimized those children, you're to have no contact with the children until such time as a Superior Court judge grants you contact through a procedure for custody or visitation. If you violate the terms of the sentence by having contact with Ms. Flores Cardona, you will be arrested and serve the remainder of the 12-month sentence in jail. You will also be charged with additional misdemeanors or felonies, particularly the felony of aggravated stalking, which is punishable by up to 10 years in prison and a $10,000 fine. Do you understand?
Yes.
Think about the fact that this woman who has children who need her was willing to risk her life by jumping out of a moving car to get away from you. You can go back with the sheriff's office.
Okay.
Yeah, that's what he's gonna get me.
Ruiz with the O. Ruiz.
So they're gonna no cross the two open container charge, and he's just gonna clean all of the other two.
To the,
No license and no tag.
I thought he was just pleading no load and no license.
That's what they know.
So here's the man of the hour. He can make sure we do it.
Disculpa, me dijiste que le puse de crear no ¿verdad?
No.
All right.
Ruiz, Your Honor.
All right, Mr. Cesar Ruiz, you're before the court on case 2026 CR 06435 for no license, count 1, no tag, expired or invalid tag, count 2, and counts 3 and 4 open container violation. Raise your right hand for me. You solemnly swear or affirm any testimony you give will be true?
Yes.
All right. You can put your hand down. Mr. Bug, what does your client plead to the offenses before the court?
Your Honor, defendant will plead nolo to count 1 and 2, and I believe count 3 and 4 will be resolved through a negotiated plea.
You mean a no pros?
Yes, I think I said handled through a negotiated plea, but there will be no process. That's correct.
Okay. All right. Mr. Ruiz, by entering a plea of nolo to counts 1 and 2, counts 3 and 4 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, to have the presumption of innocence in your favor, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes.
Factual basis and recommendation, please.
Your Honor, defense would stipulate if the court will allow.
Recommendation, please.
Your Honor, as to count 1, the state is recommending a $500 suspended fine. Count 2, the state is recommending a $100 suspended fine. The remaining counts will be no price.
All right. Mr. Ruiz, it doesn't make any sense, sir, for you to draw attention to yourself if you have no license by having no proper tag and having open containers in your car. That's not a very smart thing to do. Are we clear?
Yes.
If you're operating a vehicle, you need to make sure that you're properly licensed and the vehicle has everything properly addressed as far as tag, insurance, and any of those things. You understand?
Yes, I do.
All right.
Understand.
All right. So count 1 is $500 suspended. Count 2, $100 suspended to run concurrent, and 3 and 4 no pros. You can go back with the sheriff.
Una pregunta, ¿cuánto saldría en libertad?
I have a question, Bill.
Okay. Muchas gracias.
Thank you very much.
You're welcome.
That's why. All right. Your Honor, may we bring Artola, Artola next?
Yes.
Okay. Okay.
La gente a la fecha todo el tiempo. Acérquese un poquito, conteste las preguntas que ya le hagan.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
You can put your hand down. Mr. Deldin Artola,
Delvin Artola.
Sí.
Yes.
you're before the court on 2026 CR 06379.
Sí.
Yes.
Improper lane change, count 1. No license, count 2. Driving under the influence, count 3. Mr. Bug, what is your client plea to the offenses before the court?
Your Honor, count 1 will be no pros, count 2 nolo, and count 3 guilty.
By entering a plea of nolo to count 2 and guilty to count 3, count 1 will be no pros. Sir, you can put your hands down. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, and if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis, recommendation, please.
Your Honor, we would stipulate if the court would allow.
Not to a DUI.
Yes, Your Honor. Give me 1 second. I have the part of the report that's the DUI investigation. But in any event, so on June 14, 2026, Officer Caleb Morrison responded to North Main Street and Hunt Road in Jonesboro, Georgia, 30236, in reference to an officer needing assistance on a DUI. That officer made contact with the officer that was already on scene, Lieutenant House of Riverdale Police Department, who advised that the defendant was driving down Valley Hill Road when he observed a 2007 Honda Accord failed to maintain his lane. At that point, the original officer initiated a traffic stop on the defendant, and when he made contact with the defendant appeared to be impaired under the influence while he was conducting the original investigation. Additionally, the original officer found that the defendant did not have a valid license. At that point, the Officer Morrison took over the investigation and observed the defendant continuing to have an inability to maintain his stance. The defendant had glossy eyes, and he had an odor of an alcoholic beverage stemming from his person. The officer asked the defendant to participate in standardized field sobriety testing, to which he agreed. The officer performed the HGN test and observed out of 6 clues, and the officer declined to do any other sobriety testing at that moment due to the defendant advising he had a foot injury. At that point, the officer determined the defendant to be under the influence and read implied consent to the defendant, where the defendant agreed to breath. The defendant was transported to headquarters or to Jonesboro Police Department headquarters and was given an intoxilizer, and the BRAC was 0.135.
Recommendation?
Yes, Your Honor. As to count 2, the state is recommending a $500 suspended fine. Count 3, the state is recommending 12 months to serve, 1 day, credit for the time served. The balance will be probated for the defendant to pay a $300 fine. The defendant is to have a substance abuse evaluation and follow any recommended treatment. The defendant is to not have any drugs or alcohol and is subject to random screens and tests. And the defendant is to 40 hours of community service.
Did you say $300 fine?
Yes, Your Honor.
All right, Mr. Bug.
Your Honor, that is what we have agreed to, and we would ask the court to accept the negotiated plea.
So count 1 will be no pros, count 2 will be a $500 fine.
A $500 suspended fine, Your Honor.
Count 2 will run concurrent with count 3, 12 months to serve 1 day. Credit for time served.
Yes, Your Honor.
Ballots will be probated to pay a fine in the amount of $300. It's going to be quite a bit more than that with the surcharges, a substance abuse evaluation, any treatment that might be ordered, a risk reduction course, 40 hours of community service, no alcohol or illicit drugs during the 12 months of your probation, and you're subject to random screens for alcohol and drugs. Mr. Artola, it makes no sense to draw attention to yourself by having a vehicle that is people are going to see and think, oh, hey, let's check this out. Or by getting on the road when you're impaired and having an accident. If you kill someone, there's nothing I can sentence you to that would be worse than waking up every morning knowing that you took someone's life. You don't get to do that.
Okay,
You're going to go back with the sheriff's office and probation will contact you.
Got one more left.
Ms. Bermudez, you're getting a workout today, ma'am.
Yes, ma'am. Not going to the gym for me, Judge.
This is Mr. Aguilar Hernandez.
Yes, Your Honor.
Yes.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Sí, lo juro.
Yes, I do swear.
You can put your hand down. You're before the court on 2026 CR 06618 for Neri Aguilar Hernandez. Count 1 is no license. Count 2 is suspended registration. Count 3 is no insurance. And count 4 is no tag or expired or invalid tag. Mr. Bug, what does your client plead to the offenses before the court?
Your Honor, could the state share what counts they're going forward with?
I'm sorry, can the state share?
What's the agreement, Ms. Adams?
Which counts you're going forward with?
Well, does he have insurance?
No, he does not.
No.
So it would be count 1 and count 3, a $200 fine on count 3, $500 fine on count 1.
And is the state going to suspend the fines?
I will, in consideration of his jail time, I typically do $100 per day, but let me confirm that. Yes, I'll suspend those fines because he's been in since June 23rd.
Your Honor, we'll be pleading NOLO to count 1 and count 3.
By entering a plea of NOLO to counts 1 and count 3, count 2 and count 4 will be no prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Señoría.
Yes, Your Honor.
Factual basis and recommendation, please. I'll let you stipulate to this.
Thank you, Your Honor.
Yes, Your Honor. As to count 1, the state is recommending a $500 suspended fine. Count 3, the state is recommending a $200 suspended fine. And then the remaining counts, 2 and 4, will be no prost.
All right. Mr. Aguilar Hernandez, it's too easy to give you a ticket or pull you over if you're driving in a car that doesn't have the appropriate registration license tag decal. Count 1 is a $500 suspended fine for credit for time served. That will run concurrent with count 3, a $200 suspended fine for credit for time served. The remaining counts are no prost, and you're free to go.
Gracias, señoría.
Thank you, Your Honor.
So remaining on the calendar, I have Cornwall, Roar, and Styles, and I think that concludes everything for Ms. Bermudez.
Thank you, Your Honor. May I be
Thank you, Ms. Bermudez. Go take a break.
Sure.
Thank you, Mr. Gold.
Hey, can you do me one favor? Whenever deputy comes out, can you ask him to put Miss Roar in the booth? Actually, go call this. I'll deal with it.
What you got, Mr. Lynch?
Judge, we're gonna do Mr. Cornwall next. I believe that is a negotiated plea. And I also have Mr. Styles is a negotiated plea. And then hopefully we can, I still need to talk to Miss Rohr. I think we've cleared the area.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am. Yes, Your Honor.
You can put your hand down, sir.
Yes, Your Honor.
You're before the court on case 2026 CR 06619 for reckless conduct, Jalen Tyler Cornwall. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch, what does your client plead to the offense before the court?
Nolo, Your Honor.
By entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
Factual basis and recommendation, please.
Yes, Your Honor. On June 22nd, 2026, officers responded to the Riverwood Townhomes located at 681 Flint River Road, Jonesboro, Georgia, 30238, in reference to a person needing attention. Upon arrival, officers made contact with who is the defendant's mother, who stated that her son was having a mental episode due to him no longer being on his medication. The complainant, advised that the defendant is diagnosed with bipolar disorder and that he had been going around the house saying that he was going to hurt someone. The complainant stated that her son did not do anything to harm anyone, but that she was concerned for her and her family's well-being. The officer or the complainant gave the officers permission to go inside the residence to try to talk to the son. But after looking around the residence, the officers were not able to make contact with the defendant, who had at that point left the residence. The complainant shortly after advised that she had seen her son running through the complex with what appeared to be a firearm in his hand. The officers eventually were able to locate and make contact with the defendant, and he was observed hopping over the fence, shirtless, while throwing his shirt that contained a loaded .40 caliber Smith & Wesson handgun over the gate before jumping back into the wood line near sewer drain. The officers ultimately arrested the defendant because the defendant recklessly left an unsecured loaded firearm in an area that has a lot of young children playing outside. As to count one, the state is recommending 12 months to serve 20 days, credit for the time served. The balance will suspend as long as the defendant surrenders the firearm if it is owned by him, and as long as he has no new violations of law, and maintains his medication, remains on his medication.
Does his mother want to have contact with him?
Judge, I can speak to that. Well, I didn't mean to interrupt. Go ahead, Miss Adams.
She wasn't listed as a victim, so we hadn't made contact with her as of at this point. So I don't have that information at this moment, Your Honor.
Judge, I spoke to his mother a few moments ago. She did indicate that she's happy for him to come back to the house, but she did express that he needs to be on his medication. I've also spoken to Mr. Cornwall, who does see the need for him to be on medication. I think he's had some frustration based on not having insurance and being quoted prices for that. I have spoken to him about seeking services at the Clayton Center, and that, it's going to be somewhat that effort is going to be required on his part, but he is and does want to get medication. When he's released from Clayton County Jail, I believe he'll be going to Fulton County to deal with a matter he has over there, but then he should be released relatively soon, and we would ask that it be no violent or harassing contact with his mother. That's all I can say to that on that, Judge.
What's his mother's name?
Erica Cornwall, Your Honor.
Erica?
Yes, Your Honor, ERICA. And I also have that Smith & Wesson serial number if you need it.
Please.
The serial number is D like dog, T like Tom, 5231.
Mr. Cornwall, I'll accept your plea of nolo. 12 months to serve 20 days, credit for time served. The balance will be suspended as long as you forfeit the 40 caliber firearm, the serial number that was read into the record. You're to have no violent or harassing contact with Erica Cornwall. Do you understand?
Yes, Your Honor.
Mr. Cornwall, you need to stay on your medicine. If it's not acting the way you want it to be, you're not feeling the way you want to feel, go back to the doctor and tell him that you need an adjustment, but you got to stay on your medicine, sir.
Yes, Your Honor. I understand.
All right. You can go back with the sheriff's office.
Have a good day, Your Honor.
Can we get the female in the booth whenever that's possible? Mr. Styles can come. If we can bring Mr. Styles out, he's ready for a plea. Styles, yeah. If you will. That's Pac. I don't think that he was at a prelim.
All right, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
This is my step.
I can't hear you.
Yes, ma'am.
All right, you can put your hand down. And this is Mr.
Judge, we didn't hear that last statement.
This is Mr. Styles?
Yes, this is Keaton Styles.
You said that like we have another Styles.
Well, I'm sorry, Judge. There are two people with that last name charged on this accusation, but Keaton DeLacy Styles is in custody before you today.
All right. So 2026 CR.
Yeah, and I think you're going out a little bit. I can't hear you.
20. Can you hear me now?
Yes, Your Honor.
2026 CR 06586. Mr. Keaton DeLacy Styles, battery count 1, simple battery count 2, simple battery count 3, simple battery count 4. Mr. Lynch, what is your client plea to the offenses before the court?
Judge, it's a guilty plea to count 1. I believe count 2 would merge, and a guilty plea to count 3 and a guilty plea to count 4.
By entering a plea of guilty to counts 1, 3, and 4, count 2 will merge with count 1. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, and if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
Factual basis recommendation, please.
Yes, Your Honor. On June 16, 2026, at approximately 7:30 p.m., officers were dispatched to 1951 Southampton Road, apartment C3, in reference to a physical fight in progress. This address or this incident occurred within Clayton County, Georgia. Upon arrival, officers met with 3 individuals who were involved in the fight, who stated that a woman who resides in apartment D3, along with her brother, who is the defendant today, and her boyfriend, came to the rear patio of their apartment and began attacking them. All 3 of those individuals reported that the woman's brother physically assaulted them by punching and slapping them, while the female's boyfriend was swinging a pocket knife at them. Officers made contact with the defendant, or first I should mention that the officers observed the victims to have, or at least the youngest victim to have, a swollen left eye and a small bruise to the upper portion of her chest. The other 2 individuals sustained minor injuries that were not visibly apparent. The officers made contact with, or actually the officers did not make contact with the defendant at the scene, because the defendant had left the scene at that point. But a photograph, the officers were able to pull up a photograph through RMS, and the 3 victims did positively identify the defendant. The photograph was shown to all 3 victims, and they positively identified him as the person who punched and slapped them during the altercation. As to count 1, the state is recommending 12 months to serve 30 days. Credit for the time served. The balance will be probated for the defendant to complete 40 hours of community service. And then the balance can suspend as long as we have no contact with the victims and no new violations of law. The one of the victims' name is Kanaya Ross, Kaniya Ross, common spelling. Another victim is Darlene King, Darlene, King, common spelling. And then the third victim is Mahia Morris, Mahia, Morris, common spelling.
Mr. Lynch? So I got 12, it's 12 months to serve 30 days credit for time served, balance probated for 40 hours of community service and no contact. That's on all 3 of the guilty?
Yes, Your Honor, and they're going to be run concurrent.
All right, Mr. Lynch?
Judge, I'm asking the court to accept the plea as negotiated. Mr. Stiles is taking accountability for what happened, although he doesn't want to make further statements about it because of the fact that he has family members facing charges out of this incident.
So I understand neighbor disputes can get kind of hairy. I'm clear on that, but I just don't understand how this got so far out of pocket. And you lose all high ground when you go to the person. If you had stayed in your place and they came to you, that's a whole different thing. You're not in jail at that point. But when you leave the ground you rent or own and you go to the place where they are and they are in where they're supposed to be, but you come to the fight, you lose. That's where you end up in jail. And it just doesn't make any sense. How old are you, sir?
I'm 40.
You how old?
40.
Sir, street fighting at 40. At this point in your life, your knees creaking. Your knees starting to creak. You starting to have aches when you get up from a chair. You too old for this foolishness. That's a young man's game. And if you still have the mindset that you're gonna handle some business at 40 years old by going to fight people, you have not made any progress from high school. If you are in the same mindset at 40 years old that you were in middle school or high school, let's go handle some business, you have wasted all of those years in between. You have not progressed mentally or emotionally through all of those years. You've wasted time. You wasted it. If you are not in a better mindset, a more grown-up, mature mindset than you were in middle school or high school, where you at 40, when your knees are going out, your ankles ain't the same, and you could literally, one of my cousins sneezed and broke a rib. This is the phase of life we are in. And you trying to go handle some business. But, sir, be so for real. I just really need you to really focus on why that made sense to you. I will accept your plea of guilty to counts 1, 3, and 4. They will run concurrent, 12 months to serve 30 days. Credit for time served, balance probated for you to do 40 hours of community service and to have no new violations of laws of the state of Georgia, and no contact with Kanaya Ross, Darlene King, and Mahia Morris, who all sound like females. And I don't know that you're supposed to be fighting women, but hey, that's how you get down. That's probably why you're in jail. No contact. And let me just tell you what happens if you have contact. So the remainder of your sentence, you'll come back to jail, and the court will consider you spending the remainder of that sentence, the 11 months you got left, in jail. You can also be charged with additional misdemeanors or felonies. You could pick up a felony if you don't pay attention to what I'm saying. So when I say no contact, not through a third party. Don't have none of your cousins, friends, buddies, Facebook friends. Nobody reaches out to these people on your behalf. You're not to call, go by, look twice at their house. If you walk past their apartment, you need to keep your head straight and keep it pushing. You understand? All right. You can go back with the sheriff's office. All right. So I believe that leaves Roar.
We're gonna bring Miss Roar out for a plea.
And did Pat come up, or are we
Pat-
needing to?
Pat
Huh?
did come up. I'm gonna talk to him while we.
Okay. All right, raise your right hand for me, ma'am. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on State of Georgia versus Kristen Page Roar. Am I pronouncing your name properly?
Yes, Your Honor.
2026 CR 06620 for theft by shoplifting, count 1, theft by deception, count 2, giving a false name, address, or date of birth to an law enforcement, count 3, and obstruction of an officer, count 4. Mr. Bug, what is your client plead to the offenses before the court?
Your Honor, we would plead guilty to count 1 under Alford v. North Carolina, and I can provide more facts when appropriate. And I believe the other counts may be null pros.
All right. By entering a plea of guilty under Alford versus North Carolina, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes, Your Honor.
All right, factual basis recommendation.
Yes, Your Honor. On 2nd, 2026, officers who were at the Walmart located at 7050 Highway 85, Riverdale, Georgia, 30274, doing an investigation, was made aware by the loss prevention employee that the defendant skip scanned items, skip scan makeup items, and then passed through the self-checkout without completing payment of all the items. The total retail value of the skip scan merchandise was $34.93. And the total value of the merchandise that was deprived from Walmart without payment at all was $47.91. And at the time that the defendant attempted to exit the store without rendering full payment, the officer detained the defendant. As to count 1, the state is recommending 12 months to serve 20 days, credit for the time served. The balance will be probated for the defendant to complete an anti-theft course, and then the balance can suspend as long as the defendant does not return to the Walmart located at 7050 Highway 85, Riverdale, Georgia, and as long as she has no new violations of law. Count 3 would be a $100 suspended fine. Count 2 and 4 would be no pros.
2, 3, and 4 will be a no pros.
Or no, Your Honor, my apologies. Count 3, that wasn't a part of the negotiation. Count
Was
3.
that a guilty or a NOLO, Mr. Bug?
It'll be a NOLO, Your Honor.
All right.
But I did forget to mention the name that she provided the officer at that time.
Mm-hmm.
During the investigation, the officer requested her name and date of birth. The defendant provided the name Ashley P. Stacy with a date of birth of July 1st, 1987. And that was the correct date of birth, but her name is Kristen Ward.
Ashley Stacy?
Ashley Stacy is the name that she gave.
Ma'am, that name sounds fake. I'm gonna just tell you. You need to work on your aliases. But ma'am, you will buy makeup for what? Is that something that you need in your current life?
No, Your Honor.
Okay, so you just out here just stealing from the Walmart without any regard to the fact that if you gonna need from the Walmart, makeup is not what's gonna change your life. It's just gonna get you in jail. And this is another thing. Lean close, because it's just gonna be me and you talking. I'm gonna whisper in your ear. Do you know that Walmart has better security than just about any other place in the world? It is a worldwide company, and their security rivals like some big, like organizations that are hiding secrets. When you look into the scanning machine, there's a camera looking right up at you as you scan. What you think is under that little glass plate? There's a camera. You are probably on about 3 or 4 cameras just standing at the skip scan. So I'm not sure how you think that you're going to defeat a Walmart system. I don't know how you think that, but I'm just going to tell you, you may have gotten away with it before because Walmart decides when they're going to prosecute and they decide when they're not. So you may have, like, this may have worked before because they were like, well, we're not going to waste time getting all that together to go to court to do all of that. But you can't keep doing it. So just remember that you are not smarter than Walmart. We're clear? All right. So I'm going to accept your plea of guilty under Alford versus North Carolina. 12 months, 20 days, credit for time served. Balance will be probated for you to take an anti-theft course. Now, once you anti-theft course through probation, and you must report as directed, or you'll be right back here in jail. Once you do the anti-theft course, your probation can suspend, but you will have during the suspended sentence, you are not to go back to any Walmart in Clayton County. No Walmart in Clayton County, and you're not to have any new violations of the law. Are we clear?
Yes, Your Honor.
All right. So listen, not accusing you of anything, but I suspect there might be a substance issue here. So you may want to ask for some help if Mr. Bug has some information that he can provide to you for places that you might want to be able to get some help, or you may be able to ask the chaplains at the jail before you leave if there's some information that they have, or you can even ask through probation. They may have some information for you for substance abuse programs. Otherwise, you can always go to a community support program like Narcotics Anonymous or Alcoholics Anonymous, someplace that will get you started reevaluating how you're doing your life. Okay?
Yes, Your Honor.
Yes, sir.
I did share with the defendant that there would be a price or a cost associated with the theft class. She said she would be able to take on.
Okay,
that.
well, I'll suspend the probation supervision fees.
Thank you, Your Honor.
But she needs to take the class within the first 3 months.
Thank you, Your Honor.
Right, thank you. All right, and we're just waiting on Mr. Pack.
Hey, Judge, we're ready. Mr. Pack is ready to enter a plea today to the case before the court.
No concerns?
I have great concerns for Mr. Pack, Your Honor, and I've discussed them with him. It's not in the nature.
This is not usually his thing. I don't think.
Judge. He preliminary hearing. The strange thing is, I guess he waived his preliminary hearing on this case, but the other just got bound over today. That's for his usual line of
right. Are we trying to do a global? What are we doing?
Well, I do hope that they are run. But he's ready to accept this now. But if is there a jail calendar next week, we could do it all together. I don't know. I mean, the preliminary case should be in a posture to be accused and ready for the next jail calendar, I would think, but I don't.
I think the next jail calendar is the 28th.
That's correct.
So,
I mean, we can go ahead and resolve this case because he'll accept the offer that's being taken. But I guess, I mean, it in practical matters doesn't make sense. But let's go ahead and take plea on this just so.
Okay.
Yeah.
Bring him out.
Right.
Mr. Pack, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand out. Mr. Pack, you got to stop coming to see me so often. You understand?
I'm sorry. I'm doing the best I can. I need help.
I know you do, sir. Mr.
If I need my check turned on, I'm my own mental health payee. I have no $32 for a copy of an ID. Once I get a copy of an ID, I can stop shacking up in weird spots and pay for fixed income. I have no family either.
I got you, Mr. Pack. Hold on a second. Mr. Lynch,
Yes,
I don't
Judge.
know. Check with probation when you get a chance, because Mr. Pack has another case coming up, and this may be crucial for that. Check with them, because I believe the Clayton Center had a program where they were able to get people an ID, and it may be either no cost or very low cost, but they were like helping people replace their IDs. So if he has that information when he comes back, then that might be helpful. So let's check. We'll kind of check on that, Mr. Pack. Okay. Thank you for expressing that to me.
I get $9.94 a month. I get an ID. It's in my name.
I got you. Just let Mr. Lynch handle it. Okay.
Okay.
All right. Be still, Miss. Raise your right hand for me. Do solemnly swear or affirm any testimony you give will be true.
Yes, Your Honor.
All right. You can put your hand down. So, Mr. Pack, you're before the court on 2026 CR 06500 for simple battery and obstruction of a law enforcement officer. You're represented by Mr. Lynch. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, he pleads guilty.
By entering a plea of guilty to both, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, Mr. Pack?
Yes, Your Honor.
All right. Factual basis and recommendation.
Yes, Your Honor. On June 17, 2026, the defendant committed the offense of simple battery when he struck Officer Jihad Rogers in the right knee while the officer was escorting him to court and attempting to put him in a holding cell. Additionally, he was charged with obstruction of law enforcement. As to count one, the state is recommending 12 months to serve 60 days. Credit for the time served. Balance will suspend as long as the defendant has no new violations of law. As to count two, the state is recommending 12 months to serve 60 days. Credit for the time served, and that'll be ran concurrent to count one. And the balance will suspend as long as the defendant has no violations of law.
All right. So I'll accept your plea of guilty, Mr. Pack, to counts 1 and 2. 12 months, 60 days, credit for time served, balance suspended as long as you have no new violations, and they'll run concurrent. Okay?
Yes, Your Honor.
All right. We're going to try and get you that information about your ID, okay?
Thanks, Your Honor.
All right. Take care of yourself, Mr. Pack. I'll see you in a little bit.
It's probably going to be July 28th.
All right. So I am assuming that is it for this calendar. I'm signing. So let me know. Send it to me if you need me to sign it.
Thank you,
Sorry, Your
Judge.
Honor, could you just tell me, because I remember we said we was going to hold on the Scott case. What ended up
Yeah.
happening with that?
The Scott case, I did an MHE.
Oh, okay. Thank you.
And I thought I sent you a copy. I may have, if I didn't, then
I might have it.
okay.
I just haven't checked my email for that one yet.
All
Thank
right.
you.
Thank y'all.
Thank you so much.
Here.
See you
Okay.
tomorrow.
Ready.
And Judge, we're back on at 2.
Okay. Thank you.